And welcome to STV's live coverage of Day 2 of the court hearing of the legal bid to overturn Alistair Carmichael's election as the Liberal Democrat MP for Orkney and Shetland. 4 of his constituents have raised a case at the Court of Session in Edinburgh, saying that the former Scottish Secretary misled voters over his role in the leaking of a UK government memo about First Minister Nicola Sturgeon. Well, yesterday we saw Alistair Carmichael's QC Roddy Dunlop make his submission, claiming that the petition was irrelevant and bound to fail. Jonathan Mitchell QC, the advocate representing the petitioners, started setting out his arguments in the afternoon and will continue doing so this morning. Proceedings are due to get underway at 10:30. Well, rejoining us in the studio is James Chalmers, Professor of Law at Glasgow University, and we also have with us the lawyer David McKie. Well, the petitioners claim Mr Carmichael breached the Representation of the People Act 1983. Let's remind ourselves of what the petitioners need to prove. 1, that Mr Carmichael made a false statement of fact. The statement of fact has to be in relation to a candidate. The statement of fact has to be about the candidate's personal character or conduct. The statement has to be for the purpose of affecting the return of any candidate at the election. Well, Professor Chalmers, thank you very much for rejoining us this morning. What can we expect to see this morning when we go back to the proceedings at 10:30?
More of the same. We are going to see Jonathan Mitchell going through the arguments for the petitioners on the last of these points. He's already started his submissions. Again, it's going to be a day of fairly dry technical argument on these issues.
David, you were monitoring the stuff closely yesterday. We have most, I suppose, of Mr Mitchell's submission, but not all of it. What have you, from a legal perspective, made of the competing arguments in relation to the 83 Act?
Well, I think Mr Mitchell is going to have to hit head on, the argument of Roddy Dunlop QC, which would be a knockout blow if it succeeded. And I think that what Mr Mitchell, I expect he will do this morning, is to focus on whether or not Alistair Carmichael can be the candidate, which is one of the tests that you've very helpfully set out in your montage this morning. And secondly, whether, as Roddy Dunlop focused on yesterday, this relates to his personal character or conduct, because the counter-argument is this is about politics. And, you know, this could apply to any candidate in any election at any given time. So I think that he will probably focus in on that particular aspect.
And of course, the facts here are about political conduct. The law, in a sense, is quite different. Just remind us, James, of very broadly what Roddy Dunlop's train of thought and line of argument was yesterday.
Well, Roddy Dunlop has 3 arguments, and the good thing from his point of view is he only has to win one of them, and Mr Carmichael is home and dry. So one of them is that this law just doesn't apply to statements about yourself. The law's never been used in that way before. He says it was never intended to be used in that way. The second is the argument that, well, this is a political statement. It was a political trick. It was nothing to do with his personal character or conduct, and the law says you've got to distinguish between the two. Again, if he wins that, he's home and dry. The third one is to say, well, the statement has to be, in order for the statutory test to be met, for the purpose of affecting Mr Carmichael's return as the MP for Orkney and Shetland. Now, what he did, if it was related to the poll at all, was about the national campaign. It wasn't about the local campaign. And if any of these points are won by Mr Carmichael, he wins, which is why Jonathan Mitchell's position is quite difficult.
David, as Professor Chalmers sets that out, it is perfectly clear that the bar here is particularly high from the petitioners. Yes. I mean, the first thing a solicitor will do if someone comes to them is to make an assessment about whether or not there is a case which is well founded in law, something that is arguable. Do you even think the petitioners have an arguable case?
I think they do. I don't know that it would have got past the judge in the first instance. I've seen so many cases over many years of practicing that are unpredictable. This is the thing about court. It's unpredictable. What you require is the basis of an argument, and there's certainly the basis of an argument there. Were I a betting man, I favour the Carmichael case over the other case, but having said that, I haven't prepared the case in the way that Mr Mitchell and Mr Dunlop have. They will have looked at this intricately, and at the end of the day, this comes down to 2 people, and that's Lady Paton and Lord Matthews. They're the most important people in the room, because they're the ones who are going to make the decision. So law, as I'm sure Professor Chalmers knows, is very unpredictable. So there's certainly the basis of a case there. Whether or not you decide to take the case is something that you discuss privately with a client, but clearly they've assessed it and thought there's the basis in law for us to pursue this.
Well, the proceedings, of course, are being watched closely by Mr Carmichael's constituents in Orkney and Shetland. Our reporter, Nicola McAlley, is in Kirkwall. Nicola.
Well, good morning, Bernard. We're here again at the King Street Hall in Kirkwall on Orkney, and people are just starting to arrive. We had quite a few of Mr Carmichael's constituents here yesterday, very keen to get a chance to watch the proceedings live and to take in exactly what was being said in court. And I'm joined now for the second day by one of the petitioners, Carrie Welling. Now, back again for day two. Carrie, what's your kind of summary of yesterday, how things went?
I think that our QC, Jonathan Mitchell, started to make a really solid case for why the law does apply to Alistair Carmichael, and I'm really looking forward to today to see him finish that. He seemed a really knowledgeable guy.
And of course we saw the QC for Alistair Carmichael, Roddy Dunlop. I mean, he was standing up for most of the day yesterday, outlining Mr Carmichael's case, because of course there are two sides here, and you know, we're going to hopefully hear from the other side later on as the day progresses. People are just still arriving, as I say, but I mean, you accept that there are two sides to this story, aren't there?
I think the evidence that Roddy Dunlop presented yesterday about why the case didn't apply, even I could follow it, and I thought that it was weak.
And we were talking before, because you were saying, you know, you'd had representation from people who don't share your viewpoint, saying, why is this the people versus Alistair Carmichael? And tell me what you were saying about that.
Oh, it's a formality, like writing a letter with "Dear Sir" at the top. The people is just a bit of legalese.
So you accept you don't represent everybody on Orkney and Shetland?
Certainly not, probably less than half.
But I mean, you feel you have a strong case nevertheless?
I think we do.
And just outline for us again why it was so important for you to bring this action, to raise all this money, to allow this to go ahead.
I wanted him to resign and stand again, so that everyone could actually choose whether they gave him a second chance. That was the entire reason. I was offended by him being dishonest to us.
So you're going to be sitting here watching again avidly. More people are just coming in just now, and it's your turn to be in the spotlight today, isn't it? Because it's your QC who's going to be standing up doing the talking.
Yes, and he's a bit hard to follow members of the public, but I trust that those two judges, they know exactly what he's talking about. I think Roddy Dunlop is better at making a case to a non-specialist kind of audience, but I think Jonathan Mitchell is a pretty great QC.
Well, thank you very much for joining us again, Carrie Welling, one of the four petitioners who are taking this case to the election court. We're going to be watching the proceedings live, of course. More people, as I say, are turning up today. A few new faces here today too. The constituents of Alistair Carmichael here in Orkney, but we're also representing Shetland too as well. Let's not forget. So hopefully we'll join Carrie again, and we'll hear from more people who are supporting Alistair Carmichael too, because there were a lot of differing opinions here yesterday, shall we say, so we'll look forward to joining them again later on.
Nicola, thank you very much indeed, and we will be going back to Orkney as the morning progresses. Professor Chalmers, you very succinctly summed up the arguments which were made by Roddy Dunlop yesterday. What did you make of the opening submissions from Jonathan Mitchell? What was his line of argument?
Well, his initial argument was a procedural, quite important point about actually what Roddy Dunlop had said, and I suspect it was really quite difficult to follow, critical for me to follow what he was saying there. But Roddy Dunlop's argument was, as you mentioned earlier, that the petition was irrelevant, essentially. Even if you can prove all of this that you've got in the petition, that's not enough to force the election to be voided. Jonathan Mitchell's argument was this is not normal Scottish court procedure, which is based quite strictly on the pleadings in that way, and that actually the petitioners may be permitted to prove things, perhaps particularly related to Alistair Carmichael's intention in making the statements, that weren't foreshadowed in the petition.
And is that significant in that if the judges accept that line of argument, it raises the possibility, although no more than the possibility, that the judges may well say, we want a bit more information, and yes, we want Mr Carmichael to come to court and give evidence.
It makes it a bit more likely. I think it's nudging the door open in that direction, but at the same time, it doesn't look as if that's what the petitioners are actually actively arguing for. They're holding it open as a possibility. But Jonathan Mitchell also said he felt the case could be dealt with simply on the basis of the legal argument. So it's a possibility, but I wouldn't get very excited at the possibility of Alistair Carmichael coming to give evidence later on.
Well, let's go over to the court for day 2 proceedings. Well, both the QCs are in place, so normally the judges won't be too far behind. And of course, this is day 2, and we will be listening to Jonathan Mitchell QC. He started his speech yesterday after a near 4-hour speech from Roddy Dunlop QC, which was setting out Mr Carmichael's case. We're just about to start now.
Yes, good morning, Mr Mitchell. We're ready to begin again, and we'll have a break again at 11:30, if that's... Yeah.
The position that, as of just now, is that I've obviously spent time yesterday covering matters which substantially were not in the note of argument, and that took a little bit more time. And so today, I think I can probably go quite a lot faster. And my expectation, my hope would be that I'll either be finished or almost finished by the mid-morning break. But we'll see how we go. No promises given. Yes. Yes. I was on the first issue, and looking at my note of argument, which at this point I think I can substantially simply follow, paragraph 6, which is page 41 in the bundle. I've been noting the authorities. I've mentioned Banks against Lewis. The only other case that we have discovered that bears on issue 1 is Drachman, right, which is really an encyclopedia almost of issues under challenges to elections. And I might say, in fact, that one comment upon that, the commissioner who decided that case has probably more experience, I would say certainly has more experience in this field of law, of election petitions, than anyone else in the United Kingdom. He is the author of all the significant cases on challenges to elections in England in recent years, I think with a single exception of Wallace. So, albeit the comments that he makes on issue 1 is not made on the basis of argument, I think it's fair to take it as made on the basis of thought and consideration. This comment, which I've already pointed you to, and you have seen, is at page 931, paragraph 104. $6.22 in the bundle.
Thank you. So page 931, was that
931,
it? 931, yes. Thank you. Yes.
He's just dealt with an argument that doesn't arise here about the time, the phrase before or during an election, which has itself caused some difficulty. And then at paragraph 104, he makes the issue in relation to candidates. So that is the totality of judicial authority. We have been unable to discover commentary in the texts upon this. Section 106 has not received a great deal of attention. The texts tend to simply recite the language of subsection 1 and not take it further. There's a limited amount of commentary, not useful for today's purposes, on the personal character issue, which I won't be referring to because it doesn't actually help. There's a total absence of commentary on issue 1. Now, accordingly, the court really has to return to first principles and to common sense. The lifeblood of the law, as the saying goes. Now, we ask the question in the note, paragraphs 7 to 9, really, where would be the common sense in making the two distinctions which the respondent seeks to draw? The first distinction they seek to draw, which they say is implicit, is that it has to be an attacking statement. The second is that it has to be, with great respect, I think the argument's slightly shifted, but it has to be by somebody other than the candidate, or possibly by somebody other than the target. There's obviously slightly different ways to formulate this. But stepping back from this, one has to ask, where is the point of such distinctions? What sense might they make? And in paragraph 7, we make the point that section 106.1 is totally general. It applies to any person. The language couldn't be wider. It is perfectly obvious that in principle a candidate is struck at. How could it be said that if Mr. Woolas's leaflets had not been done under his authority by his election agent, but had been issued by him personally, that he wouldn't be liable? That there is no sense in making such a distinction. That is probably unworkable. It is clear, in other words, that the words any person cover Mr. Carmichael. It is further clear, looking at the word statement, that the limitation is to falsity.
Sorry, the limitation
is to falsity.
Right.
Now, false is, of course, a word which has more than one possible meaning. It can mean deliberately dishonest, or it can mean simply incorrect. And it's that ambiguity of meaning which is then, of course, explained by the Act in section 106. 1, when it gives the defence of having reasonable grounds for believing a statement to be true, which shows that its meaning is simply incorrect, albeit with that defence. So both these concepts are entirely general. Now, addressing then the implications of the respondents' argument in relation to the limitation they put upon falsity. The words that I think featured most often yesterday was attacking, which one I think can understand. It's another way of looking at it is injurious, which the Select Committee had rejected. But one way or another, one can understand that there is going to be on a spectrum of false statements. There are going to be statements which are clearly at an attacking end, and there are clearly statements at the other end, like the philanthropist example in Erlam, which are purely laudatory. But one question that one must ask is, how does one draw a line on that spectrum? The very commencement of this history, the debates that were pointed to in Hansard, we saw the MP for Argyll complaining about a false charge of poaching salmon. And we see the comment made in answer by Mr Labouchere that in a radical constituency, he's being the days of the Radical Party, in a radical constituency that would have done him no harm at all, would have done him good. And indeed, even today, one would have thought that a complaint that somebody had been out poaching would lose them a few votes and gain them a few.
Just be thought of a lovable rascal or something like that. No?
Absolutely, absolutely. People are looking.
It's the same thing. If someone's accused of being either pro or anti-abortion, that will win and or lose votes. And the same with fox hunting, that kind of thing.
Yes, again, fox hunting was the example in Sunderland, where we've not put the case in, but it's quoted in Bullis. There, the complaint that was hypothesised, it wasn't the actual complaint in the case, was that a candidate in a county constituency, as it was put, a rural constituency, had shot a fox. Even the phrasing seemed to suggest that if you said that in central Edinburgh, it wouldn't be a problem at all. The lovable rascal. Conan Doyle described one of Brigadier Gerard's finest exploits as being in a fox hunt where he galloped through the hounds and sabred the fox, which he was intensely proud of. The other examples we give is or is not a practicing Muslim, a Catholic. The Catholic example, historically, was an absolutely central description in much of Ireland and a great deal of Scotland and some parts of England. A candidate who made a false description of himself as Catholic in some constituencies might do so to gain votes more than he would lose them. And if the claim was made against him, vice versa. Is or is not a good Muslim? The last general election, that was a major issue. This is, I think, within judicial knowledge, in Mr Galloway's campaign in Bradford West. Is or is not anti-Semitic? Is or is not homophobic? These are all things which a calculation might be made as to whether more votes were to be gained or lost. So there on the spectrum we have the impossibility of distinguishing laudatory and attacking.
Who is to make the distinction?
I'm sorry?
Who is to make the distinction?
No idea. If there was for example, a false allegation made against a candidate in this constituency, which I think is Edinburgh South, in any Edinburgh constituency that one of the candidates was actually a secret Muslim. That's the President Obama allegation. I think we'd all be quite puzzled to know whether that gained more votes or lost. One might lead, I suppose, polling experts' evidence. We couldn't do that. We just have to say, the language of the statute, it's a false statement. And as I quote in paragraph 8, as we quote, the statute is not a graft upon the law of defamation. Even the statement in Woollis that someone was a friend of violent extremists would probably have gained Mr. Watkins a handful of votes. And then at the laudatory end of the spectrum, the substantial philanthropist. We give the example, and we give it more as one of fact, of a true story. Rather than as one of law, because of course the Act does not apply in the state of Utah. The Douglas Stringfellow story. In many ways more suited, as is the case of Trebitch Lincoln, for a Flashman novel. Mr. Stringfellow, we see from the House of Representatives archive, the article quoted, who presents this completely invented self-biography, that he is a former secret agent, which is why his name appears in no files, parachuted into Germany to kidnap Nazi scientists, imprisoned in Belsen, extensively tortured, which is why he then says falsely he's paraplegic. It wasn't even that, he walks with a limp. And gets away with this story through an election with, as the article quotes, his intrepid tale aiding him in upsetting a six-term incumbent. Why on earth should that type of false statement not be equally penalized? Just as, if one flipped that, if his story had been true, and his Democratic Party opponent had falsely claimed that it was a lie, there's simply no reason to make such distinctions. The second distinction which the respondent makes is whether it's by the candidate of themselves. Now, Stringfellow's story, of course, was issued by himself. I don't know if they have election agents in Utah. Because in Britain, one almost always does, but not invariably. But why on earth should it make a difference? The election agent is in effect authorized to give out such stories. So there are, to use Mr. Dunlop's phrase, two protagonists. The agent who says, our candidate is a heroic secret agent, and the candidate of whom that is said. Why should it make a difference? There's no sense in any of that. And sometimes, I'm sorry.
No, I'm just thinking about it.
Yes.
Yeah.
One of the, yes, it all requires the court to think about it because all of this is novel. But in my submission, it is obvious on the face of the section when one does think about it. Now, that
I think you make the point in the note that the one person who has an interest to make such a statement is the candidate himself, and he would be the one person who would not be open to criticism in terms of the Act,
Yes,
if
yes.
Mr Dunlop's right.
Yes. Trebridge Lincoln is a good example. Again, not a story which, if George MacDonald Fraser had made it the subject of a book, anyone would have thought credible. But he became Liberal MP for Darlington. He was a Hungarian citizen. He falsely told his own party that he was a naturalised British citizen. He was ineligible for election. He was the only person, in truth, who knew that. Historically, candidates tended to stay quieter, so it might be that one wouldn't often see these false statements from candidates. But there's no reason to make a distinction on that basis. Nor does the Act. And I'm here on paragraph 9, the other sections of the Act, which clearly strike at false statements made by one person of themselves. And I think the only example, because I don't want to spend a lot of time on this, that I need point to is paragraph, I quote four sections, 62, 62A, 65 and 63A, is page... Yes, at page 161, the case of section 62A. The person commits an offence if A, he engages in an act specified in subsection 2 and intends by so doing, so this is the purpose, to deprive another of an opportunity to vote or to make for himself or another a gain of a vote. These are the acts. B, otherwise making a false statement in or in connection with an application for a postal or proxy vote. So this could be anyone. It may not, of course, be even somebody connected with the campaign. There have been repeated suggestions, reading the works of Commissioner Murray on electoral fraud in recent years, by campaigns in which fraud has been shown, that the fraudsters had nothing to do with them. But equally, it can be the candidate. And then, again, subsection 2 of section 106, that in the note of arguments at page 38, for convenience. This deals with agents. The word agent has, for historical reasons, a much wider meaning in this area of law than under the ordinary law of Scotland. But the distinction is there between the election agent, who's a statutory creature, and other agents. It deals with the question of false statements committed by agents other than the election agent, authorised or consented to by either the candidate or his election agent. Now again, no distinction is drawn here. And it is obvious from this that false statements by agents in general, including the election agent, are caught. Then we have section 67.2, which is also noted in my note. It's page 178 in the bundle, but I don't think you need to turn that up because it's quoted here. This makes no sense if one makes the distinctions pointed to by the respondent.
Perhaps we could just look at section 67.2. Yes.
Yes, it's 178.
Right, page 178. Yes. Right, yes.
Yes. I think in practice in parliamentary elections, it would probably be almost unheard of for someone to name themselves as election agent. Mm. But certainly in local government elections, it might well happen.
Right.
Again, on Mr Dunlop's construction of the words in section 106.1, a person, brackets, other than the candidate. That this would, section 67.2 would make no sense. There are, of course, scattered through the Act, duties that lie upon a candidate and there are duties that lie upon an election agent. There are also duties such as the sections that I've noted at the top line of page 44 of my notes, such as the postal votes, that lie upon both of them or upon everybody. So I think really that's all I have to say upon issue 1.
Yeah.
Except the bold observation that this is a question of pure law, and on no view, I think we're agreed on this, could there be any requirement for evidence at a proof. So far as that is concerned, this court can come to a conclusion. I'll say something at the end as to the implications of that. Now, the second issue relating to personal character or conduct is one which both sides present as being a matter of pure law. But in truth, it does have a factual element. And indeed, it's only because it is accepted by Mr. Carmichael that he said what we say he said. It's very trivial differences in wording, but they don't matter.
Mm. Yes, there were some corrections in the answers.
Well, whether they're corrections or not, I'm not really whether they're right or wrong, I don't know. One has to listen to the
tape.
The
Yes.
tape. Neither of us are suggesting you do that, because
No.
there's nothing that matters between us.
No, nothing that matters, right.
And we also have, of course, the Daily Record statement, which isn't disputed. But there is some factual context to this. And I'm not sure at this stage that there's really anything in that factual context that might justify a proof. So certainly at this stage, I take it the same way as the respondent does and say that this is something upon which a clean answer can be given at this stage. Now, you have our argument on this matter at paragraphs 10 to 13 of the note of argument. Much was made by the respondent of the case of Woollis as the leading up-to-date authority on this question. Great respect, I think, it's the description, a laudatory rather than attacking description of the decision in Woollis as up-to-date is rather contradicts what was also said as a matter of law about the approval given, looking at the decision in Barras, to the more ancient statements.
So just take us through that then, Mr.
Well,
Mitchell.
what was said as a general proposition of statutory interpretation by reference to the case of Barras was that where one saw a judicial pronouncement on the meaning of a statutory provision, one then saw that Parliament has reenacted this in the same terms, that the earlier statement acquires greater authority from that parliamentary approval. Now, of course, all of that is well-accepted law. I don't take issue with that description of Barras at all. It does have the consequence, however, that it's the older cases, if anything, which become the more valuable. But I'm not ultimately seeking to make a distinction on this, but my position upon this is that Woollis, North, Louth, if I'm pronouncing it right, and nobody was able to tell me, and Erlam, which has something to say on this, are all correct in their analysis. Ultimately, it may be very hard to draw a bright line distinction between statements which relate to personal character or conduct on the one hand and statements that don't. The importance of the distinction is not an issue. It is not in dispute on this side that there is a category of statement, a false statement, which may be made in an election of a candidate with the purpose of affecting the election, which does not generate the sanctions of Section 106. And that is the category of statements which do not relate to personal character or conduct. Now, it's perhaps unhelpful to gloss the section by reading into it that category is defined as ones relating to political character or conduct. But clearly a statement which essentially does so is not in the section. Banks against Lewis was the clearest example. Someone who falsely states, it's no longer technically possible, given changes to the Act, it was then. Someone who falsely states that they are the official Labour Party candidate is clearly making a false statement that is not in relation to their personal character or conduct. And the examples are repeatedly given in the cases. The candidate who falsely states that he voted against social security cuts whenever he could in the last Parliament, falsely states that he or she was always opposed to the war in Iraq, anything of that kind. These are not personal character or conduct statements. The reason why that distinction is an important limitation is fully described in Willis, which explains the interaction between the section and Human Rights Act, rights of freedom of expression. There are, of course, sanctions elsewhere. There is the Standards Commissioner in the House of Commons, but not under this provision. And accordingly, the respondent is perfectly correct in their underlying proposition, his underlying proposition, that if this court finds that he made a false statement within the meaning of the Act for the purpose of affecting the election, which was, however, a purely political conduct statement, did not relate to his personal character, then with one leap he is free at this stage. Now, whether that's good or bad as a matter of policy is not for this court. But it is equally important to recognize the public interest in the proposition that false personal statements do void the election. I'll mention later the get-out clause on that, which has not so far been referred to, but the broad proposition, taking even the respondent's example, if I, in an election, as an election agent or as a candidate, if I tell lies about my opponent, well, it doesn't need to inquire, did it affect the election? It's surprising to see that as late as last night, there were false, incorrect explanations being given on this, on, for example, the BBC. Yes. Whoever wrote that can't have listened to any of this, but nevertheless, there is a distinction that is drawn by the Act. If I, as an election agent, say of the other candidate, he's a man of violence, the Willis example, that voids the election. Nobody asks. It's not a legitimate question. Did it make a difference? There is a distinction which the Act draws, obviously, if it's somebody who's not in the campaign. That distinction is drawn by section 106 2b. The unauthorised false statement if I, as an unauthorised partisan, that was at section 38 in the note, sorry, page 38 in the note. If I, as a completely unauthorised partisan, make false statements, then there has to be a decision of the court that the election was procured or materially assisted. It doesn't mean decided by. But so far as the people who are at the heart of the campaign are concerned, the candidate and the election agent, and the authorised agents, that makes no difference. Now, that may be hard, but it's for good policy. Because if I, as an election agent, as in Bullis's case, make a false claim, no belief in its truth, that the opponent is a man of violence, and I do so to affect the election, it would be outrageous if I could be heard to say that none of this mattered. Underlying this, and it's sometimes put in rather purple prose, especially in the earlier cases, is the importance of the purity of the election.
That's why they're called candidates, isn't it?
I'm sorry?
That's why they're called candidates.
Yes. Yes, absolutely, yeah. Thank you. Yeah. Yes, I'd forgotten the derivation. Therefore, the court, in asking the question, is this in the section or not, is not in the position in which it has to say beyond reasonable doubt. It is. And to say that there's no other possible explanation. It's simply asking a straight binary question. Is it or isn't it? Now, I've given a full description of our argument in paragraph 11, 12 and 13, which you have both read probably several times and will again, so I don't really want to go through it again. Can I look at the case of Willis, which is the high point of the respondent's argument? Now, Willis, of course, is primarily given to the question of whether the election court is subject to judicial review. I'll mention this at the end, but of course it decided that it was, and that has never been doubted. But then the question today is the false statements of fact in relation to personal character, and that part of the decision begins at 862. As my lady and my lord will remember, the election court identified 3 statements as coming within the section. The divisional court disagreed on one of them and agreed on the others. All 3 statements had a very obvious political background. All 3 had very obvious political consequences. All of them are made during the election campaign. That combination of facts, however, is not sufficient to determine the issue. It is not enough, in other words, to say, well, this is just part of the ordinary political barney that goes on in every election. It's of interest to note how the court ultimately draws the line between Statement 1 on the one hand and Statements 2, 3 on the other. Statement 1, in which the two courts disagreed, was the choice of address, choice of residence, rather. That's described, the election court's decision is described at page 864, paragraph 71. The election court noted this, a statement of fact, he's reneged on his promise to live in Oldham East and Saddleworth. And it held that ultimately that was a promise which was within the performance of which, between C and D, was within his control, so that failure to honour it reflected on his personal trustworthiness. Now that high water description of personal character or conduct was not accepted. And an important part of the reason why it wasn't accepted, of course, was the court pointed out that in truth it was not wholly within Mr. Watkins' control, any more than it would be of anyone else. A promise on my part to go and live in Oldham East. There's all sorts of reasons why I might have to go back on that. But there are deeper reasons why it distinguished, which I'll come to. The second statement is then quoted, and again is worth looking at. Same page, opposite letter F. E to F, rather. The leaflet as a whole had to be seen. Accordingly, the statement had to be seen in its context. I don't have the impression, I have to say, that simply reading the cold text, that 1,000 words are really worth more than the one picture, which isn't in the law report. What we have here, of course, is a statement about Mr. Watkins wooing the extremist vote. Just below, a photograph of the people he was apparently wooing. The actual language in its context, the court accepted, would probably not be enough to bring this into personal character. Wooing extremist vote. And then, in his attempt to woo the vote, he has called for Israel to be isolated from arms sales, but not Palestine. That the election court held, was factually false, because he'd actually publicly stated that there should be a ban on arms sales to the entire region. But the statement itself takes its bite, its sting, from the photograph, as both courts held. The election court held, the next paragraph, that the ordinary and reasonable reader would understand the phrase. Just in parentheses, I don't think anyone disputes that that is the manner in which this court should approach it. What would the ordinary and reasonable reader understand by the statements? The statement he attempted to seek electoral support of Muslims who advocate violence, in particular to Mr. Woolas, is one of fact. The statement describes conduct. It is not a value-laden statement. They then distinguished this from another article: if militants are allowed to succeed, no moderate MP of any party will be safe. It's just a comment. And the court continued in another unexceptionable statement, just opposite C on the next page. Of course, a statement about someone's intention can be a statement of fact. Now, that was the basis upon which this was ultimately held to be a correct description by the election court of this as a statement about personal character or conduct, that he was in effect a friend of violence. The election court's description in paragraph 75, page 865, E to G. And we have that. It was also an attack, it said, in his political conduct because the advantage sought was an electoral victory. I have to say I would have thought that was correct, but the divisional court in Willis said that it couldn't be both. I have to say I would have thought it was common sense would suggest that this was an example of both, because it does attack his political conduct. But nevertheless, the question is, does it attack his personal character or conduct?
So the proposition at paragraph 111 that it cannot be both a statement about personal character or conduct and a statement about political position or character, are you disagreeing with that then? You say this is an example of both.
I'm not sure that I need to disagree with it for the purposes of this case. What I say is that the question before the court is it a statement about personal character or conduct?
Yeah.
That's the language of the Act. One can draw a broad dichotomy between the two. But the court itself, having said that, went on to say that this statement was both. At paragraph 121.
128.
121, I'm sorry.
121. Right.
The 120 to 121.
Yeah.
This is just dealing with this particular one, issue 2. Also the other one, it's pretty much the same in the other attack. Those whose votes were being wooed by Mr. Watkins were those who were not simply extremists, but those who advocated extreme violence, in particular against Mr. Willis. It plainly suggested, as the election court found, that Mr. Watkins was willing to condone threats of violence in pursuit of political advantage. It was not then a statement about the type of support he was wooing, but a statement that he was willing to condone threats of violence. That further statement, that's the implied statement from the positioning of the text underneath the picture. Because it's nowhere expressly stated, quote, he is willing to condone threats of violence, unquote. That further statement took the statement from being a statement as to Mr. Watkins' political position to being a statement about his personal character, that he condoned criminal conduct. It is not simply an implied statement in relation to a political matter, comma, but a statement that goes to his personal character. Right. Now, I find it with great respect to the court. I haven't been able to reconcile these two paragraphs.
This is 111.
And 121.
Yes, I see your point.
Yes.
Yes, in a sense, 121 is saying, even if you identify something as being a statement connected with political, how do they phrase it, in 111, yes, political position or character of the candidate, it may develop into something affecting personal character or conduct.
And it may do so because of an implied sting. Looking at what's described as to this issue, the statement in the Examiner, the text is pretty innocuous in terms of section 106. It's the fact that it appears immediately underneath a photograph. A photograph of people holding placards, and so in effect incorporates what's on the placards: behead those who insult Islam. Ultimately, what I think the court is meaning in this is that a distinction has to be drawn between statements which are one as to personal character or conduct, or merely a statement as to political position or character. But the problem with this, of course, is that it is all in a political context. And indeed, that is in the nature of section 106.1. We're talking about statements made during an election, the ordinary way by those at the centre of the campaign, because of the distinction drawn later in the section as to ones made by the partisans, the outside partisans, and also because it has to be with the purpose of affecting the election. So in that sense, there's always a political element in it. In the taking even the clear examples of personal allegations, the statement, he is a practicing Muslim, he is homophobic, that sort of statement. All of these have a political context. It's not enough to say it has a political context. And from that point of view, there is ultimately room, they say in paragraph 11, perhaps for differences of opinion. But because the test for the court is how does the statement appear to the ordinary and reasonable reader, that is ultimately not an evidential question. In the ordinary way, no doubt there might be cases where it would require evidence. Now, when one tries then to disentangle from Willis where the dividing line lies, in my submission, it's particularly helpful to look at how ultimately the line comes to be drawn. Statement 1, not in the Act. Statements 2 and 3 are. Now, I should say I'm not going to be very long on this, so perhaps if I just finish the description of Willis at this stage.
We could have a short adjournment
after that.
Right,
yes.
Yes, that would be fine.
Yes. When one reflects upon the underlying statement, if one lifts this out of a campaign into things that people just say as the years go by when they're talking politics at home or in the pub, and I say of my MP or of another candidate, they went back on their promise to live in the constituency, no one is going to take that as in truth a personal criticism of that candidate. And that becomes the more obvious when I'm not doing it in the context of an election. I'm just doing it about a common acquaintance. Myself, the other people in the pub. It would have been laughable, and I'm not saying this to be pejorative about Oldham East. It was the same if it was in Brunsfield. It would be laughable to say, it's a personal criticism of somebody to say that they promised to go and live in Oldham East, and in the event it didn't. It equally clearly be true that to say of somebody that they associate themselves with violence is personal, out with the election campaign, out with politics. And if I say that in condemnation of a mutual acquaintance to a friend, that so-and-so is a supporter of beheading people who they disagree with, that would be seen as a personal criticism. And underneath this, that may be so because it's an allegation of criminal conduct. But the personal stretches beyond the criminal, non-criminal divide. Essentially, it's a moral attack upon them. It would not be an answer in that context if I say that somebody associates with the beheaders, that they weren't committing any criminal offence by so associating. And that is the line, in truth, which is drawn by the divisional court. Paragraphs 120 to 124 at page 879. The distinction that is there drawn at paragraph 121, the statement that he's willing to condone threats of violence, which takes it into being a statement about his personal character, that he condoned criminal conduct. So far as I'm aware, it's not yet a criminal offence to condone criminal conduct. It's certainly a moral or personal statement, just as are, in the ordinary way, statements that somebody is dishonest, or, to use other examples which were discussed in the cases, that someone is corrupt. I'll come to this after the break, statements such as they betray secrets to, as it was there put, foreigners. But betraying of secrets is clearly a statement about personal character or conduct. Now that's really, I think, fairly well wraps up what I have to say about Willis before I look at the other cases with an attempt to tease out the distinction.
Yes. Well, that's very helpful and convenient. So we should stop now for a short break of 10 minutes and reconvene as near as possible to 11:45. Court will now adjourn.
Well, with the court taking a short break, let's get reaction from Professor James Chalmers to what we've been listening to. Again, this is all very technical, very complex and very dry, but much of the submissions which Jonathan Mitchell has been making there are based on previous cases all around this issue of what is personal conduct as against the political. What have you made about what he's been saying?
Well, I think there are two key points that have come out of the discussion so far. The first early on has been his attempt to reject any suggestion that the legislation might only apply when you're smearing another candidate, because, as he pointed out, that distinction becomes very difficult to make. You could well have statements which actually have a mixed effect. So the example I think was given at one point of support for fox hunting. If you falsely allege that a candidate supports fox hunting, depending on the constituency, they might lose some votes, they might gain some votes. So it's not easy to isolate statements which are smears from statements which are laudatory in the way that the respondent might want to do here. The second point which came out was some scepticism about the distinction between political and personal conduct. The court has said, or the courts in England in dealing with election petitions have said, you've got to draw a distinction between personal and political conduct. You can't say that a statement relates to both, and it's only statements about personal conduct which actually engage the law. Now, his position here was interesting because he wasn't outright attacking that, but he was saying that actually that's a difficult position to hold. And in fact, if you look at the case, the Phil Bullis case where the court laid down that distinction, it didn't do a very good job of drawing it itself, and it talked about statements escalating from ones about political matters into personal matters, but not really explaining how they stopped being political matters when that happened.
Right. Well, let's take one clip from the hearing that we've just heard, and we can pick it up with Professor Chalmers again.
The second distinction which the respondent makes is whether it's by the candidate of themselves. Now, Stringfellow's story, of course, was issued by himself. I don't know if they have election agents in Utah. Because in Britain, one almost always does, but not invariably. But why on earth should it make a difference? The election agent is in effect authorised to give out such stories. So there are, to use Mr. Dunlop's phrase, two protagonists. The agent who says, our candidate is a heroic secret agent, and the candidate of whom that is said. Why should it make a difference? There's no sense in any of that.
So what's he driving at there?
Well, part of that is going back to one of the earlier points made by Roddy Dunlop yesterday about whether the legislation encompasses talking about yourself. And again, this is all tied together. The respondents are arguing for quite a narrow interpretation that this legislation is really all about smearing your opponents. That's all it deals with. Yeah. And what Jonathan Mitchell is trying to show is that some of these distinctions don't hold if you really push at them very firmly. And it's quite difficult to sustain the case that they're trying to make.
Presumably because, of course, when you start to look at the tests, if you read this legislation as only affecting your opponents, it would be pretty difficult to make anything stick on Mr Carmichael. But if it's his conduct that's struck at by the Act, all of a sudden his conduct comes into play. Absolutely. I mean, the petitioner's case is entirely based on Mr Carmichael's own statements about himself. So they've got to make this argument in order to gain chance of success. OK, grand. Well, what has Mr Michael's constituents made of today's proceedings? Back to our reporter Nicola McAlley, who's in Kirkwall.
Well, yes, people busy discussing in the break what they're making of proceedings this morning. I must stress that we do have representatives from both sides, people for the proceedings and those who are here to support Alistair Carmichael, but they don't want to talk to us quite at the moment. I'll talk to one of the ladies who is here in support of the proceedings. Just tell us what you're making of things this morning.
This morning, I mean, I think along with most people, we'll be finding it quite difficult to follow. But I mean, I think once you actually have time to go away and analyse it, you can see, from the perspective, for myself, I just find it difficult that we're actually being asked to separate the political man from the man himself. I mean, it's not that we can't do it. For me, it's actually, should we be doing it? I mean, we've done that once before. I mean, we allowed the bankers to do what they did under the guise of being bankers, but that doesn't make it right. I mean, most people looking on at this can see that what he did was actually, to the detriment of the First Minister and the French Ambassador. But to separate the two things doesn't make it right. I mean, most people looking on just see that, well, he shouldn't have done it. I mean, he was actually representing Scotland at Westminster. And actually, you should be able to look up to these people. And I think in this instance, I don't think we actually can.
So lots of talking still going on. Jonathan Mitchell QC making points. I mean, he said the public interest, is the proposition that the personal statements do void the election. I mean, what's your view on it all?
I too am finding the points of law difficult to follow this morning, and this conflict between the personal and the political, it's a point that clearly needs to be sorted out. But I mean, I'm here primarily because two of the petitioners are close friends of mine, but also because I've lived in Orkney for 27 years, and I feel in the past we've been served well by our politicians on the whole, and I feel that has changed. And I feel that damage has been done to the trust and confidence that people here have in the political process. So I think although these points of law are difficult to follow, it's quite important to try and understand them and to see the way that this case is progressing, because I think this matter does need sorting out.
Well, thank you very much for joining us, ladies. As we say, there are supporters of Alistair Carmichael's here in the room. Some of them don't want to talk at the moment. We'll try and get a word with them later on. Obviously, lots of points of law, lots of past cases being discussed here to make particular points, which we're all doing our best to try to keep up with. Everybody here very, very interested to see how the rest of the hearing is going to pan out, because obviously it's a huge issue for Orkney and for Shetland and for the constituents of Alistair Carmichael.
Nicola, thank you very much indeed. Nicola McAlley there in Kirkwall. I mean, just picking up what was said there, that these people are finding this extremely difficult to follow. I mean, you're the Regius Professor of Law at Glasgow University. You're one of the top academic lawyers in Scotland. Have you found any of this difficult or awkward to follow?
I've certainly found it easier today because we now have a copy of Jonathan Mitchell's note of argument, which has been put online. So I encourage people to seek that out. It very clearly sets out the petitioner's case. I think it was much more difficult yesterday when we didn't have that background to work with. And it's always difficult watching court proceedings where actually there's a lot of paperwork, there's a lot of material being referred to that you as the observer don't know about, and you haven't put the time into it that the counsel and the judges will have done. Certainly the written argument makes the position a lot clearer here.
Just in terms of the note of argument, we've managed to run off. This is the note of argument that Roddy Dunlop submitted yesterday. Just sort of take us through what's the sort of status of this document and how is it presented to the court, and when the advocates get onto their feet, is it this document that they're speaking to?
Yes, well, this is actually, it's not Roddy Dunlop's argument, it's Jonathan Mitchell's argument. I think that Roddy Dunlop's has been made available, but I haven't been able to find a copy of it as yet. Essentially, the judges will have had this in advance. It sets out, I think, what we were all expecting, because it was identified in advance what the key points in this debate were going to be, and it simply fleshes out in more detail what the advocates are going to have to speak to. So, does this cover what's been referred to as self-talking, is the new word that we've all learned during the course of these proceedings? Does the statement refer to Alistair Carmichael's political character or his personal character? And was it made with the intention of affecting his return in the election? So we knew that those were the key points, but having it set out here enables you to see just exactly how
it does. When you, I mean, I've just skimmed it, but it does seem very, very logical. So. Yeah. When a solicitor engages a counsel, how do they go about drawing up a document like this?
Well, the first document which was drawn up was the petition itself, which had to be lodged within a very short timescale. And one of the things that came out in the argument yesterday was Jonathan Mitchell was quite candid about this and said, well, we actually had to do this in a matter of days. Yes. So actually it wasn't nearly as fully developed as you would like a legal argument. It couldn't possibly be. That's not an admission of any sort. It was simply impossible in time available. This is something which has been prepared much near the time when the issues between the parties have crystallised, and trying to say to the court, look, actually there's some very narrow points that we're dealing with here, because you saw, for example, in the report we just had from your correspondent, one of the points is being made, well, this was an attack on the First Minister, it was an attack on the Ambassador, this is inappropriate, and you can see how people might be angry about these things. But that's not what the case is based on. The case isn't based on Alistair Carmichael leaking. It can't be. There's no legal remedy for that as far as this is concerned.
And has it actually helped that they didn't have a great row over essentially the facts of the case, that they've been able to broadly agree about Mr Carmichael's conduct?
It certainly made the proceedings shorter and easier. We've seen some election court proceedings south of the border where there has been a huge amount of factual dispute about exactly what went wrong, where there have been allegations of really electoral misconduct. And so actually very long evidential hearings with witnesses, with cross-examination. So these are much more narrowly focused proceedings. They're also a lot less theatrical.
Presumably what's happened here is that counsel look at the relevant sections of the Act, they look at the facts which are not in dispute, they look at the previous case law in this, and they try and bring it all together in a submission which is logical and legal and makes sense.
They're both trying to show how their own position flows on from the previous authorities as a matter of inevitable logic. And they're doing that perhaps in slightly different ways. So part of the petitioner's case is saying, look, the language here is quite simple. The legislation refers to statements about any candidate, any person. Alistair Carmichael's no different. Statements about himself are clearly covered. The respondents are trying much more. Well, if you look at the history of this, it's clearly been about smears. It's clearly been about attacking your opponents. This is not what it's meant to cover. So they're coming at it from different directions, but the directions that suit their own position best.
And presumably these notes of argument are the starting point for the judges when they come to make the determination, as well as obviously the verbal submissions which have been made over the course of the 2 days. Yes,
it may well be the case that the verbal submissions are not adding a huge amount to what is actually in these written documents, because you will have legal arguments being presented where there's a lot of intervention from the judges, there's a lot of debate, a lot of questions. There hasn't been that much of that in these cases, so it's an opportunity for counsel to amplify points that they think that are particularly important, but actually the written documents are probably going to be key to the decision here.
Do the judges, when they take all of this away, do they accept as read what's in here, or do they have to go back and reread all the earlier case law to see whether or not the interpretation of that case law that's been put on by the respective counsels is one that they're reasonable to conclude?
Yeah. They may well, if they are themselves going to, in their judgment, rely on particular cases. They want to check that what they're saying is accurate. They're relying on the fact, of course, that both parties are represented here. So if one counsel said something which was flat out wrong about a particular case or a particular piece of legislation, you can be fairly sure that in short order, counsel for the other side would be pointing that out. And there's no doubt here that this is a well-prepared and thoroughly prepared case,
okay.
So that's not going to happen.
Let's go back. The court is about to resume.
Yes, Mr Mitchell.
Yes, I think I'd finished on Woollis, really. But,
right.
But of course, Woollis is only one in a series of cases.
Yes, and we just wanted to ask for your views about whether it's binding or otherwise. Do you think it has any binding?
It's not.
Not, no.
One of the problems about the chain of the use of precedent in these cases is there is really nothing provided for but a first instance court. And I've made the point before that it is a first instance court through the United Kingdom. It just happens to be here Scottish judges, or in Woollis, English.
Yes.
And this is jumping forward, but I was going to say it anyway, to how decisions might become binding. Because the decision of the election court is not appealable, it is subject to judicial review. Now, of course, Woollis was primarily about that question. But it has clearly stated the law in that regard in Scotland as well. This court is judicially reviewable in the Court of Session. There are awkwardnesses about that, and most obviously the fact that a judicial review in the first place goes to a single judge. But all of that, of course, can be dealt with quite easily because an outer house judge could simply report the case to the inner house. But there is potentially room for binding decisions along that line. But meanwhile, that is what you have in Woollis is simply a divisional court decision, which is itself a first instance decision. The other route by which one gets, of course, to a binding decision is the statement of a case to the inner house. Well, perhaps I'll come to that later because I have a note on it which I haven't got in front of me.
Yes.
But Willis is not binding. From that point of view, in a sense, it doesn't really matter whether it's English or Scottish as a case. But it isn't binding any more than cases like North Louth, which, of course, was an Irish case.
Right.
What I would say, I think, about Willis is that there is a difficulty. If one was to regard it as binding, it would be quite difficult standing the apparent dissonance between paragraphs 111 and paragraphs 121 onwards.
Yes. There is a difficulty.
Yes.
Yes. Right.
Well, there is a difficulty. And
Well, it looks as if paragraph 111 has stated matters too simplistically.
yes,
Yeah.
it has. It has.
Yeah.
That said, what it says is important, and in a simplistic way is true. That there is a distinction to be drawn in broad terms between the statement. An important point that is made, going up one paragraph at page 879, is about the concept of a statement being about a political position.
So where, sorry,
That's
where is that?
in Willis at page 879, paragraph
879.
120.
Right.
A simple statement that Mr. Watkins was wooing the extremist vote, that would be a statement in respect of the political position of the candidate. A statement about the votes the candidate is wooing is a statement about his political position. And equally, the characterizing the people he is wooing as extremists, assuming that this is a statement of fact, possibly rather doubtful, but still, is no more than political hyperbole. The characterization of supporters as extremists in a political context, and of course all these cases are in a political context, whichever way one goes on this, is a statement about the political position of those who he is wooing. Now, the concept of the political position is significant because something which, as it is put, a few lines from the bottom of paragraph 121, something is taken from being a statement as to Mr. Watkins' political position, and if that's the distinction, I think it's probably right to say that something that is only about a political position could never be personal character. If I say of another a candidate I'm against to, he is opposed to proper pensions, that's purely about his political position, even assuming it to be fact, not opinion. There's nothing personal in that. I mean, one of the difficulties, of course, that one has about political positions is exactly the penumbra between fact and opinion. In personal character, one might have a similar penumbra. But nevertheless, that's not the issue. Political position, pure and simple, takes us out. What we have here, however, is the bite, the sting. Now, there has to be a line that is drawn here, which in some ways may be difficult, because some candidates might say, my political position is entirely based upon matters which you, the hostile voter, might regard as personal character because they're just immoral. The later case of Erlam gave an example here. And in Erlam, there was the example, that's 622 at page 971. There, at paragraphs 379 onwards, the petitioner's case, which was successful on this matter as on all others, was that the campaign had been run on the basis of portraying the Labour Party candidate as a racist, a crude but ultimately successful attempt to persuade the electorate that the Labour candidate was racially prejudiced, inherently hostile to those of non-white ethnicity and those of the Muslim religion. And then they look at what is racism, under the heading racism, under the heading racist. And he says at 381, there can be no doubt that to call a man a racist is to make a statement of fact in relation to his personal character or conduct. But I think in truth, although that's correct nowadays in this society, it might also be a political position. I don't suppose that successful Nazi Party candidates for the Reichstag election in 1933 would have had any problem with this as a statement of their political position. They wouldn't have seen it as a personal verdict upon themselves.
There's an overlap with questions of immigration. Very often, those who are in favour of tighter immigration are perceived as racist, and
yes,
there may be an issue there.
There may be an issue, and there may be difficulties, because there may be a lifting. Somebody who says we should impose tighter controls on immigration. Underneath that, there may well be a racist position. But the position may not be. Statements such as this, of course, are often used as what the Americans call dog whistles.
What the Americans call?
Dog whistles, something which can only be heard by a certain audience.
Right.
A statement in election material. For example, the candidate on the other side is in favour of lifting restrictions upon immigration. Can be well understood by racist voters as an appeal to them as racists. Another example, anti-Zionism. It is not a statement about somebody's personal character that they're opposed to the practices of the Israeli government, but notoriously anti-Zionism as an accusation, just as Zionist on the other side, are used as ways to conceal statements about Jews. And a person who says, I am an anti-Zionist, has to know a little bit more about them, perhaps, to know whether they're making a statement about a political position, or whether this is a nod and a wink, dog whistle statement that they hate Jews. Sometimes one can get to the root of that, and sometimes one can't. But what I think one has to have ultimately is this, an understanding of what is the true sting of the statement in its context. In the attacking context, of course, these questions come up. One can usually discern that. And one can usually discern, taking Lord Matthews' example, statements about restrictions on immigration. One can reach a view as to which side of these dividing lines they fall. But underneath it, pure political position is not personal character. But pure personal character is not political position. The divisional court didn't like the older statements in the older cases that referred to attacks upon honour, veracity and purity. But in truth, that is what this is about. Banks against Lewis. There was no criticism of Mr. Lewis's honour, veracity or purity. And he presents himself as a Labour Party candidate when he isn't. It's an attack upon his political position. One useful way of looking at this is to ask, how would this appear if this wasn't a politician? I used that example before the break in the context of the discussion in the pub about condoning violence and the like. The present case is a very strong example of this. Mr. Carmichael's statement, in which he falsely states, to use his word, he was dishonest, that he was not aware, that he had nothing to do with this. And suggests slightly obliquely that this is some civil servant whose identity he knows. But clearly this could be about a non-politician.
So clearly?
That could be a non-politician who had done the leaking.
Right.
And clearly the untruth about it could be too.
Clearly...
The untruth could be by a non-politician.
The untruth, which one, just to clarify?
Oh, the untruth, falsely stating I was not aware. If Mr. Rodden had been on Channel 4 instead.
Right. So you mean a non-politician could have made that statement that I didn't know what was going on? And,
yes.
Yes, I wasn't involved.
Yes.
Right.
In the context of a leak of secrets, there's no particular reason why the question of reputation, personal character will be different between a politician and somebody else. Indeed, it seems to have been accepted that it wasn't very different between Mr. Rodden and Mr. Carmichael. It is critical to remember here that the criticism of Mr. Carmichael is not the leak. That was dealt with by the Cabinet Office inquiry. That was not to leak this document was not a false statement within the meaning of the Act. And no one, I think, has ever suggested that it might be. It's the denial of personal responsibility. And the denial is clearly one of personal responsibility.
This is an important issue. Is the leak of this memorandum personal conduct itself, or is it a political act, the leak of the memo?
The difficulty in answering that question is twofold. The first is we don't really know enough about it. We've never addressed the question of what were his motives for doing that. The second was that it is not a false statement in that sense, in the first place.
Well, that's what I'm concerned about, because A, we have a false statement. I did not leak that memo. So, if that's a false statement, it's got to relate to public or personal character or conduct.
Yes.
And does it relate to the leak of the memo? And if so, is the leak of the memo personal conduct?
The leak, if one was to address this in terms just of the memo itself, Mr. Carmichael has said that he now accepts that what was in the memo was not correct. That's in one of the productions, his apology letter. But for present purposes, it doesn't matter. If I leak a memo which is true, which is accurate, that's a leak just as much as one that isn't. Yeah. My motives are likely to be much the same. But the question is the false denial later that I had responsibility. The leaking of the memo, not using the language of the Act, but as a matter of non-statutory approach, it might be a false statement about somebody that I publish or propagate a memo which contains a false statement about that person. False in the sense of incorrect rather than deliberately dishonest. But for the purposes of the denial, none of that matters. If the memo had been entirely correct, there had been no misunderstanding about the conversation that it recorded, and it gave an entirely accurate account, then obviously it would not in itself be a false statement. But the denial of responsibility would remain.
Now this is, the problem is that accepting for a moment your argument that needs to be accepted, this was a false statement, however one categorised it as a misstatement or whatever. To what does it relate? It must relate to whether or not Mr. Carmichael was responsible for the leak.
A little bit more than responsibility, but he takes it beyond that to awareness.
Aware, all right.
So, but nevertheless, it doesn't matter. There's an acceptance, there is a false statement.
It relates to his knowledge of
Yep.
the leak, put it in that sort of terms.
Yes.
So does the issue not come to be whether the leak itself and his awareness of it is a matter which refers to personal character or conduct rather than political?
Well, with respect, my lords, they're mixing up two questions, whether the leak itself is and whether the awareness is, the knowledge of it. What he is doing, can I look at it the other way round? Mr. Dunlop used a useful analogy when he said, let's look at the inverse of this, if the criticism's made the other way, if it's made as a criticism back of Mr. Carmichael. Assume for the sake of argument that Mr. Carmichael had been entirely truthful on Channel 4 and to the Daily Record. He'd had nothing to do with this. He had no responsibility. He had no awareness. He's telling the truth. The flip side would then be if another candidate went on Channel 4 the next evening and said he's lying. He was aware of that. The flip side wouldn't be the leak, whether the leak was correct or incorrect.
No one's I'm not suggesting that.
No, no.
What I'm interested in is the denial a statement, a false statement about the leak?
No, it's a false statement about his mental awareness.
All right, of the leak.
Yes.
Right, so is his awareness of the leak, his authorisation of the leak and so on a matter of personal character or conduct, or is that a matter of politics?
His authorisation of the leak is probably quite hard to characterise between personal and political. I will come on that, the proposition that it can be seen as personal to the case of North Louth. But it's not the authorisation of the league that's an issue, it's the denial. In North Louth...
No, with respect, I'm not sure that's right. And if it's accepted that the denial is false, then we know that's false.
It's
so
whether
the
it's
question is,
personal
to what does the leak, to what does the denial relate?
It relates to his personal conduct in asserting a lie. Perhaps I can just point to this, to some of the things that Mr. Carmichael has himself said about this.
Sorry, just before you do that, Mr. Mitchell, you were saying it relates to his, and I just didn't catch the phrase you used when you were saying, Lord Matthews asked you, we know about the denial being false, but to what did the denial relate? And you responded, it relates to, I don't know if you can remember the words you used.
I'm not sure.
His personal conduct in asserting a lie, I think. Is that what
his personal conduct in asserting
a lie. Thank you
Yes,
very much.
yes,
His
that sounds
personal
right.
conduct.
Yes.
That's it, thank you.
Yes.
In asserting a lie. Right now, and then you were going to help us further. Yeah.
But does that not mean then that every time a politician tells a lie, one can say that that relates to his personal conduct because he's lied?
No, because we come back to the way that the sting might cut according to whether, suggested it's important, whether it's a politician or somebody else. If Mr. Rodden had done this, it would be exactly the same. If any civil servant had done this. It's about their personal character and reputation. The statements of political position, the court pointed out in Woolwich that to a large extent those are beyond candidates' control, that one really cannot, the court really cannot start getting into questions as to how far statements of political position are true or false. And the court can't get in indirectly by saying, you said that you would oppose all social security cuts, but in fact you don't. Therefore, you're lying and you're hypocritical. Because underneath that, that's so interrelated with the question of what are the social security cuts? Are they good, are they bad? How's the economy moved, etc. If I can point on this to how Mr. Carmichael himself characterises this, which is some value, not because he is the judge of the question, but because what he says on this makes good sense and fairly characterises the issue. There's a good description of this. We have it in our the footnotes to this part. In the first file, item 5.5, which is the Orcadian 4, I can't actually read the date, May the 28th. This is the respondent's own description of this as being about personal character. The front page, there are people whose trust and confidence in me has been damaged, and I have to rebuild that. over the page, he describes on the first column, speaking to the Orcadian on Tuesday, he admitted he had candidly let down his supporters. That's by the denial. And a few...
Where is that?
That's the first full paragraph in the first column on
oh,
page
yes,
70.
I see it. Thank you. So first full paragraph in the first column of
page 70.
Page 70,
yes.
right, yes.
And there's then the criticism that he had denied on record having any knowledge of the leaked memo. Channel 4 is quoted, the Daily Record is quoted. Asked this week why he had in effect lied about his part in the leak, he replied, "I made a serious error of judgment. For that I have apologised. I wasn't wholly truthful about it. I understand the damage that has been done to the relationship of trust." This is all about the personal relationship. The next page, page 71. The bottom left, the view from Westminster. This is, of course, his column in his own words. So this is perhaps the fairest description, be fair to him, that one can get. I've already said this at interviews and statements. Since this space is mine alone and the words here are not edited by anyone but me, let me say it again. I understand that my behaviour has done damage to the relationship of trust, as I have with many of you. I regret that more than I can say, and I am truly sorry for what I have done. Not just for giving my agreement to the disclosure of the memo, but also for not subsequently being truthful about it. Two more paragraphs. A community in which there is no hiding place. The impact of my behaviour is felt not just by me, but by my family, friends, and supporters. Now, if it's purely political, why is it felt by family?
Yes, I'm sorry, I haven't located that on
I'm
page
sorry.
71. If you could tell me
First,
again.
it's the left-hand column.
Left-hand column, right,
Yes.
of the view from Westminster, yes?
Yes, yes.
So it began at, is it the third paragraph? Or?
The third paragraph begins, "I have already said this."
Yes.
I read that.
Right.
I understand that my behaviour has done damage to the relationship of trust
Right.
that I have with many of you as your Member of Parliament.
Yeah.
He regrets that.
Right.
Not just giving my agreement to the disclosure of the Scotland Office memo, but also for not subsequently being truthful about it.
Right, thank you.
So it's a purely
And
personal point that's made on the second.
Yes. So there's a reference to friends and family, is that
Yes,
right?
that's just down. He describes how he's been Member of Parliament,
Oh, yes, I see it now.
Yes.
Thank you.
made our home and raised our children here,
Yeah.
community in which there is no hiding place. Then he says this, "The impact of my behaviour is felt not just by me, but by my family, friends, and supporters." Now, supporters, I can see, doesn't really go anywhere, but family. Why is the impact felt by family? Unless it's personal character. There could be no answer to that. A political position might have an impact on supporters, but not on family.
Well, I think when a politician meets with hard times, for whatever reason, it can affect family, whether it's political or personal.
They often just wheel the family out, don't they, for the cameras?
I'm sorry, I didn't hear.
They wheel the family out for the cameras quite often.
They may do.
Well, they may do.
Yes,
but here's the impact back after the wheeling out, after the election.
Yes, but at all events, I mean, I don't think we can assume just because there's a reference there to family and friends that this is personal as such. And it can be that one's political career has hit a very bad patch.
One can't assume anything from single statements.
No, no.
I fully accept that this has to be seen simply as part of the general context. What I do take from this is that he is characterising this as about his personal character and conduct, and not simply about a political position. It's an impact that it has on his personal reputation. We come back, as I say, looking at the inverse of this. If everything he said had been true, and an opponent had gone on Channel 4 the next day, the inverse would not be an attack qua memo. It would be an attack upon the cover-up. It's not the original sin, it's the cover-up, which is the more important. We're not complaining about the fact that he leaks a memo. We're complaining about the fact that he lies about his personal awareness. And if somebody had gone on the next day to do the reverse, that person would have been saying, Mr. Carmichael lied yesterday when he said that he had no awareness. Mr. Carmichael lied about his knowledge. The truth about involvement in an incident is more significant than the incident itself. But what we have here...
Is that the real other side of that coin, that the question, if an opponent had come on television or whatever and said, never mind what Mr. Carmichael said about it, and just simply said, Mr. Carmichael leaked that memo?
Oh, that would be what he might have said the day before Channel 4 interview, perhaps. The inverse, as I say, if somebody had said, if Mr. Carmichael had said nothing, if he had simply said, I refuse to take questions about this, I have better things to do, and somebody had said, well, as a matter of fact, he did leak it, there'd be no contradiction between these two statements.
Well, yes, but what would be the effect if as a matter of fact, Mr. Carmichael had nothing to do with the memo and was not aware of it, and someone had said, he was aware of this, he leaked it?
That would be...
Would that relate to his personal character or conduct, or would that relate to something other than that?
I think the proposition that somebody has leaked, I'll mention that in connection with the North Louth, what was said about that there, the leaking of secrets. But that's not what the inverse is. The inverse is he has been lying about this.
Yeah,
it's the equivalent.
Humour me for a moment.
No,
what would the position be if someone had simply come and said, quite wrongly, that Mr. Carmichael knew about the document and he authorised its leak? Would that relate to a political matter, or would that relate to Mr.
No,
Carmichael's
I think
personal
I'd have to say that relates to a personal matter on the authority of North Louth. But I am keen not to pitch my case more high than I need to.
So you said that would be personal character or conduct on the basis of a particular authority?
Passage in North Louth, yes.
Right.
But
right.
I'll come to that.
All right, if you're coming to
I'll come to that. Well, I might as well just come to it now. North Louth is tab 66. It's in the first file, first bundle. We comment on this at some length in our note, but just going through the decision itself, this is another two-judge decision, of course, and it arises in the context of an election between different factions of Irish nationalists. At that point, the Irish Parliamentary Party, the Irish nationalists, were deeply split between one faction and between the official faction and an unofficial faction. Mr. Hazelton, referred to here, was the official candidate. Mr. Healy, who was the sitting MP, was the dissident. The judgment begins at page 120. Mr. Justice Gibson. And he says that the elections challenge on every ground of objection created by statute and also for general intimidation and contrivance. And he lists these under their headings, and close to the foot of the page, publication of false statements as to the personal character and conduct of Mr. Healy by Mr. Hazelton's election agents. He notes the length of the inquiry. He notes its history at the top of page 21, that very unexpectedly, after somebody finally told the truth in the witness box, the respondent's case on the merits collapsed. But nevertheless, the court took the view the matter was one of public concern, and the trial went on. Much of the judgment is accordingly devoted to the other matters. At page 574, the court comes to the sixth head, the violation of the 1895 Act, and states its limitations. I needn't go through that part of the history, but at page 577, it said at the foot of the page here, the question is not one of innuendo, but of common sense. The word personal, no doubt, is restrictive, but I doubt if the sole antithesis is political. Public, or any other similar position, would equally well fit the distinction. Now, what he then gives is examples of what would come within the section. A general recommending officers for promotion who had lent him money. A minister who betrayed cabinet secrets to a foreign friend. It's the top of page 578. the minister who betrayed cabinet secrets is a long way of saying leaked. I should say, it's not in dispute in this case, of course. The original memo was highly confidential, most importantly, because it was the confidence of the ambassador of a friendly state. Would be guilty of official and political misconduct, which is a matter of public concern, would merit comment. But such conduct would at the same time involve personal delinquency. If such person was candidate at an election and a false charge of the above character was made, would it not be a false statement as to both personal character and conduct? Yes. Considering that, then, the minister who betrays cabinet secrets, who betrays confidential documents, the Daily Telegraph, are the same. So, coming back to Lord Matthews' point, that even if one analyses this in connection with the criticism, if I make these allegations this false charge of this character, a false charge that Mr. Carmichael was a minister who betrayed confidential documents, the Daily Telegraph. That would be a false statement as to his personal character and conduct. And the reason why, ultimately, it would be so is that this is fundamentally dishonourable conduct, which goes beyond politics. There's no more or less dishonourable, whether it is done by the minister or the civil servant. That's perhaps the key to this. So that when I make a false charge against a candidate that they have betrayed, using this language, cabinet secrets to a foreign friend, it doesn't really matter whether it's a minister or not. It's something, looking at the next paragraph, it may not impute corruption. The recommending officers for promotion is probably corruption. Betrayal of foreign secrets might or might not be, according to whether there was gain involved. But for the purpose in hand, the only difference between corruption and willful and dishonourable breach of duty is one of degree, not principle. Now, we then have the next example, which is more obviously political. If a candidate professed to have been a consistent supporter by his vote of old age pensions and trade unions, and a leaflet falsely charged him with having opposed them by his votes, would not the statement affect his veracity and honour even more than his political character? I think one now has to answer that rhetorical question as saying, but it's nevertheless really in the box of the Woolers phrase, political position. As the Lord Chief Baron observed in O'Shea's case, I should say that's a case of which no report has survived. There is no sharp dividing line separating what is personal from what is political. Woolers, I think, is in line with that. The real question is, what is the true meaning of the letter and the leaflet? Considering the occasion of publication, the persons publishing, the person attacked, the readers intended to be addressed. There is then a description, without reading this very lengthy judgment at great length, the basic attack that Mr. Hazelton's leaflets made upon Mr. Healy was that he and his friends were, as it's put, seeking clandestine government favours on the cloak of his parliamentary position. And the reason why that was personal was that Mr. Healy portrayed himself as having, in effect, a moral position upon this matter that went beyond politics, which is described at page 158 to 159.
Right, so what is the description then?
At 158 to 159, the occasion was a nationalist election, meaning by that between two nationalists. The intention manifestly was to make an imputation injurious to his candidature. The persons publishing were the United Irish League. That's the official, the Irish Parliamentary Party's constituency organisation. Mr. Hazelton, a member of the official Irish Party, bound by the self-denying ordinance, that's an ordinance upon members of the Irish Parliamentary Party. It's inconvenient and improper for any member of the party to use influence, direct or indirect, to obtain paid government situations or promotion of any kind whatsoever for any person. The obligation prohibits a member from getting government positions for himself or his family and connections. Mr. Healy claims still to belong to this party. He was bound by the obligation. The Irish Party have had a record of stainless purity in their loyal adherence to this noble self-abnegation. It was behind that, it was unique. No political party in Britain at the time, meaning by that the island of Great Britain, took this sort of position, obviously. Nor historically had Irish politicians, as one sees by the history of Phineas Finn and the Palliser novels. Some even interpret it as binding, but this is really a moral commitment. It's put improper. And thus, a claim that one's broken it is the odious personal insult. The way that it had been attacked was as it's put, a tabulated family list that Mr. Healy's families included people, one of whom had become, for example, an English judge, and so on. Other examples are given. The leaflet, I think, is at 581. But this is something which goes beyond political position, because albeit it's a commitment of the Irish Parliamentary Party of the time, it's essentially a moral commitment rather than a political position. Put it another way, there would be no criticism at the time. No doubt it would be in 2015, but it wasn't a criticism at the beginning of the last century, in 1911. But a person used what influence they could to do what good they could for their family and friends. The reason why this is described as a noble act of self-abnegation was that unless there was this moral commitment, there would be no bar. So even the fact that this emerges from the ordinance of the party doesn't detract from its essential character as a personal attack. And we return thus to the comments at the top of page 158, the example of betraying secrets. Now there you require no ordinance of a party to tell you shouldn't do that. Nevertheless, it has a political background. It's a willful and dishonourable breach of duty. Whoever betrays and so, coming back to the point that my Lord Matthews was talking about, the false accusation, the hypothetically false accusation made the day before the Channel 4 interview would only have been he betrayed these secrets to the Daily Telegraph. And on the authority of this, that would be an attack upon his personal character and conduct.
So the obverse of that then would be, I think on your argument, if I'm correct, that the false denial of betraying secrets, if you put it that way, is itself a false statement as to personal character or conduct?
Well, absolutely. But I was looking at this, I got into this originally, I've spent much longer than I'd expected to on this matter, but it is difficult. And it's novel. And in particular, there are difficulties caused by trying to turn this round into the language in the cases of attacking statements. But if Mr. Carmichael had the sense to say to Channel 4, I'm not saying anything about this, others could have drawn their own conclusions as to his personal character. Was he a betrayer of secrets or not? It might have been said he doesn't deny it. But what he does is he puts, as he makes clear in the article in the Orkney, his own reputation on the line on this. If he'd said to Channel 4, I refuse to comment, I refuse to answer, people might have formed their own view. He puts into the scales the reputation which he describes in the Orkadian for personal trustworthiness, for personal honesty, and he founds upon that. And that is purely personal, because whether or not the leak is political, nothing in politics, except the desire to influence the election, nothing in politics called upon him to lie about this.
I still have the problem that if the leak and the awareness of it was not personal conduct or character, then a false statement about that would not be struck at by the Act, would it?
The false statement is the putting of one's personal reputation on the line, as he describes in the Orkadian, and it is his denial as to personal awareness that we found upon. But I appreciate, to put it firstly, most generally, of course the context of any statement is important. In some context, one doesn't have to bother because the underlying conduct is purely personal anyway. even if there's a political background, it may be a personal act. The example in North Louth, which was given about an MP having an affair with another MP's wife, I forget where it is, but, sorry? Oh, I'm sorry, it's in Earlham against Drachman. The most obvious example of that, of course, is Parnell and the affair with Kitty O'Shea. The political background and the reverberations of that were tremendous and continue to affect history in these islands. But underneath it, it was just an affair. It was a personal matter. And if he'd been falsely accused of having that affair with another MP's wife, that would have been a personal attack. And it wouldn't have mattered whether or not he was falsely denying that. One would still just look at the original matter. Here, I think it is more important because there is this difficulty my Lord's identifying in categorising. But underneath this, I do think I have to stress this in a way that's not brought out in the note. The betrayal of confidences, the betrayal of secrets is essentially personal. May be driven by a political motive. It has to be, in this context of Section 106, driven by a political motive, because otherwise it wouldn't be for the purpose of affecting the election. But that's not enough to exclude it. But it's not a political act that one betrays confidences. It's not a statement of political position. No one goes to the electorate on a platform, "Your secrets are not safe with me." There's some suggestion in the answers that he did this in his capacity of a cabinet minister. Of course he didn't, because if he had, there'd never have been any need for a cabinet investigation at all. The capacity was that simply of an ordinary person who happened to be in possession of the secret and who was also a candidate at the election, so he had a purpose. And thus our summary of this matter in paragraph 13. Come back applying the Woollis dichotomy. Looking at what he says to Channel 4 in the Daily Record, this is not about politics. The leak is there. It is visible that the leak has come from government in the most general sense. The question is whether it's him personally that's involved. That is about him as a person. Thus, indeed, the general description which he gave of this in the Daily Record article is interesting. It was at page 64 in tab 5.4. Underneath the photographs the record asserts a civil servant was behind the leaked memo. Mr. Carmichael has fingered an official in his own department for writing the note, but of course it wasn't the right, it's just, there's two acts, it's writing and the leaking, and he fingers for both. Carmichael said yesterday, I know the person involved, but I'm not going to go beyond that. This is not somebody in public life, it's a civil servant. So he's entitled to the inquiry being done properly. And so he goes on, Cabinet Secretary is the person to hold an inquiry. Not my job to tell him how to do this. The first time I saw the memo was in the pages of the Telegraph. Asked the memo as an example of dirty tricks, he said, these things happen from time to time. I think it's regrettable. All of this, what he's doing, is making clear that it doesn't have to be a politician. And indeed, as the record rightly put it, he's fingering a non-politician. And a non-politician would have had exactly the same complaint against him if they'd done this. A dishonourable breach of duty. They'd been lying. May reflect upon the obvious misleading of the inquiry, which had been set up. My learned friend said, I think per incuriam, the inquiry was set up on the 5th of April. In fact, we know it was set up on the 4th. It doesn't matter. But clearly the inquiry, as we see from its report, was forced to go through everything before it finally got an admission. Mr. Rodden, in many ways, is equally to blame, although I think it's always distasteful to blame the junior. He got his authorization. But a civil servant who'd done this off his own bat would have been equally under attack. As Mr. Carmichael makes clear.
Would it have been equally, just, I didn't catch that word, would it have been equally?
Under attack.
Under attack, right.
Indeed, as we saw from the Cabinet memo, the penalties suffered by Mr. Rodden and Mr. Carmichael were effectively identical. Mr. Carmichael said, accurately, I know the person involved. Footnote, we now know, of course, Mr. Rodden, but I'm not going to go beyond that. This is not somebody in public life, it's a civil servant. And he makes the point, it's not about public life, it's private, personal. Now, I don't think I can usefully say anything more on issue 2. I have spent far longer on this than I'd planned to, and I don't apologise because I think that it's novel material for this court.
It is.
And it's important, and it's tricky.
Indeed, yes.
But I can deal relatively shortly with other issues.
That's fine. We could either do that or adjourn for lunch, but just let me check with Mr. Dunlop. Mr. Dunlop, you're not seeking a right of reply, are you?
I think on some of the matters...
On some of the matters you are.
Fallen from my learned friend, yes, my lady, but I wouldn't imagine being long if I was allowed perhaps 20 minutes.
20 minutes. Right, well, just...
I can get through issue 3, I think.
Before lunch?
Before lunch, just to get it out of the way. Because what I have after that are really just housekeeping matters about this court's procedure.
Well, proceed with issue number 3 then, yes.
Issue number 3. In effect, that came into the foreground of what I said yesterday. The only attack made by the respondent on issue 3 is the proposition that the petition does not comply with traditional Scottish standards of relevant pleading. I've dealt fully with that. There is no attack upon our note, our Rule 69.13 note, as not complying in that sense. clearly it has to comply at one level because it has to give fair notice. So the court, I think, can deal with this very shortly on the basis of what I said, going back to the 19th century cases, that this is not a relevancy attack at all. And the only question accordingly, so far as issue 3 is concerned, is something which really goes into what I call the housekeeping issues of what to do about it. Does the court simply, in effect, find in my favour de plano, or does it do something different?
Right.
But that goes into a more general question about what this court's powers are,
right,
which is a separate chapter.
Yes, and that's your final chapter of address to us.
Yes, it's a short one, as I say. But it can be left over.
No, well, that's fine. I think that's a convenient moment to break. So what we'll do is adjourn now and reconvene at 2 o'clock. 2 o'clock.
And so that's adjourned for an hour. When we come back at 2 o'clock, we'll get the final submissions from Jonathan Mitchell QC before Roddy Dunlop has a right of reply to some of the points which have been raised. Professor Chalmers, there was actually a period there when there was quite a lot of interaction between the QC and both of the judges, and I suppose that it got to the heart of this whole issue of, is a leak personal or political? There was a lot of exchanges between Lord Matthews and Jonathan Mitchell. What did you make of them?
Well, I think the difficulty there for the petitioners is that if the leak itself was a political matter, then that might lead you to the conclusion that any statements about it, including whether you were involved or not, are themselves political because they're statements about a political matter. And of course, at that point, the petitioner's case would collapse because this has got to be a statement about personal character. So you could see that was causing, I think, some difficulty for Jonathan Mitchell. He had an answer to it, but it was a difficult point to put. It was a difficult point because Lord Matthews kept coming back to the point, is a leak personal or is it political? And Jonathan Mitchell at that point, and of course this all goes to the heart of section 106, had referred to a column in the Orkney newspaper where Mr Carmichael had said that his behaviour has done damage to the relationship of trust. And his argument there was, well, that can only be personal. But it did strike me at that point, the judges, insofar as you could tell anything, weren't actually buying that as an argument. No, the issue for the court here is the legal distinction which is thought to exist between personal and political statements, and that's not something which is going to weigh on anybody's mind when writing a column from the Arcadian. Alistair Carmichael wasn't writing that column giving an explanation of the difference between these two legal concepts. He wouldn't be particularly qualified to do it, even if he were attempting to do it. So I think the judges were sceptical of what they could make of that. It's certainly a point in the petitioner's favour, but it's not the strongest of points. It probably was one of the points in the hearing which was most accessible from the point of view of the public. So let's just look at it again, because as I say, it goes right to the heart of one of the tests that the petitioners have to meet in terms of section 106.
Then he says this: the impact of my behaviour is felt not just by me, but by my family, friends, and supporters. Now, supporters, I can see, doesn't really go anywhere, but family. Why is the impact felt by family? Unless it's personal character. Be no answer to that. A political position might have an impact on supporters, but not on family.
Well, I think when a politician meets with hard times, for whatever reason, it can affect family, whether it's political or personal.
They often just wheel the family out, don't they, for the cameras?
I'm sorry, I didn't hear.
They wheel the family out for the cameras quite often.
They may do.
Well, they may do.
Yes,
but here's the impact back after the wheeling out, after the election.
Yes, but at all events, I mean, I don't think we can assume just because there's a reference there to family and friends that this is personal as such, and it can be that one's political career has hit a very bad patch.
One can't assume anything from single statements.
No.
I fully accept that this has to be seen simply as part of the general context. What I do take from this is that he is characterising this as about his personal character and conduct, and not simply about a political position.
So there we have it, this whole issue of the personal against the political. And as you rightly say, Professor Chalmers, Jonathan Mitchell spent a lot of time of this explaining this out, and he kept coming back to the point. Did he spend so much time on it because he knows that unless he can persuade the court of this, the petition's just going to fall?
Yes, well, that's true of all the points that he's making, but you could see that there was some difficulty in the questions coming from the bench, and he really wanted to reinforce the point as well he could. And that's why you got much more detail of some of the earlier cases, which do help his position here than I think you would have otherwise.
One of the other cases which he did refer to earlier on was the Woollis case. Now, this was a case after the last general election campaign where the election court effectively set aside the result. Now, right at the very beginning of his comments today, he said, or he was, I think, asked by the judges whether or not they regarded the point in Woollis as binding on this court, and he said, no, it didn't. So just from a legal perspective, explain to the viewers what the whole issue of binding means in this context.
Well, the court in Woollis said there's a difference between political statements about political character, statements about personal character, because previously in that case when the election court heard it, the judge there said actually a statement can be both, and the judicial review said no, it's got to be one or the other. Less turned in that there, but here it's absolutely crucial. Now, normally courts are obliged to follow decisions on points of law by higher courts, but the point Jonathan Mitchell was making is the court that heard that case in England, it's not a higher court technically, it's not one which binds the election court here. It's a decision to which they'll pay a lot of attention, but they're not absolutely obliged to follow it. Now, what wasn't then quite clear was whether he really wanted the court here to say, and that was wrong, and we're not going to actually take that approach. He was a little more nuanced there and said, well, I don't think I really have to make that point, but the door's open.
But do the points that flow from the Woollis case in any sense help Jonathan Mitchell in his arguments? I mean, I could see why he wouldn't want something to be it's not binding because it's not a superior court, but you might argue that something's not binding because the legal point doesn't actually help you out.
The key legal point in the Woollis case for now is that distinction between the personal and the political, which doesn't help Jonathan Mitchell. It would certainly be easier, I think, for him to make his case if the earlier position that had been suggested there, that actually something can be both, still held. And it's clear that there is some difficulty in the reasoning that the Woollis court gave in saying you can distinguish these, and then it talked about things changing from or moving from the political into the personal in a way that didn't really explain how they stopped being political. And I think another way of reading what goes on in Woollis is to say, well, look, the political can become the personal, but it doesn't stop being the political at that point, and that would make Jonathan Mitchell's position a bit easier.
Okay, well, these are all issues ultimately that the two judges have to wrestle with as a matter of law. I thought that last section was actually a bit more accessible, a bit more easy to follow. Did people in Orkney think the same? Let's go back to Nicola McAlley.
Well, yes, Bernard, I think so. I mean, the personal or the political, well, the people at the heart of this, as you say, are here in Orkney and in Shetland. Alistair Carmichael's constituents who have been sitting through day 2 of the hearings, and I'm joined by people representing both sides of the coin now. First of all, Carrie Welling, who's one of the petitioners, who joins us again. Carrie, now that was your QC, of course, Jonathan Mitchell. Do you feel he's doing a good job and getting your point across here?
I was a bit disappointed. I think we got bogged down. Where we got bogged down is I don't think the court understand that this is not about the leak. It's about the cover-up. And Mr Mitchell's strategy of inversion in argument, this debating society type strategy, didn't work well. It was very confusing, and I was disappointed.
He did make a point earlier on. He said it's not the original sin, i.e. the leak, it is the cover-up which is more important. He did stress that, but you don't feel he's stressed that clearly enough.
I don't think Lord Matthews was comfortable with that, was he? I mean, he kept coming back and back and back and back to the leak. And he wanted to know if that was personal or political. It's irrelevant. It was a catalyst for the cover-up.
And we're also joined by Dennis Gowland, who is a supporter of Alistair Carmichael's, and we were hearing about an article that Mr Carmichael had written for the local newspaper, the Orkney, where he was talking about the impact this has had on family and friends. That point was being debated. Well, does this make it personal now? I mean, what's your take on that?
I think it's rather unfortunate to use Mr Carmichael's words of contrition and twist them against him. I think these really meant. And, you know, I feel the case being put forward today was highly convoluted and really like trying to cram a square peg into a round hole, to be quite honest. I think it was very difficult to follow you know, some of these reasonings and to try and, it's a rather tenuous connection. And I think the bench seemed to be quite bemused by some of these kind of novel approaches.
So we're all watching here with interest in Orkney and in Shetland too. So obviously day 2 of hearing is not concluded yet. We're going to be coming back, certainly the court's coming back after lunchtime, and I think we're going to hear from Mr Carmichael's QC then too. But certainly a lot of questions here, I think, still in Orkney and in Shetland as to how the hearing is going. So for the moment, back to you, Bernard.
Thank you very much, Nicola. Rather interestingly, one of the petitioners there expressing disappointment about the general tack which the QC has taken there, and Carrie Welling saying it's not about the leak, it is about the cover-up. And of course, although there was a lot of time taken up this morning with this, I mean, Jonathan Mitchell was actually very, very clear at one point when he said, we are not complaining about the fact he leaked the memo, but he personally lied about it. And again, it gets back to this whole business of personal conduct, because that is essentially what is covered by the Act. James Chalmers, I suppose that we, in a sense, shouldn't read too much into the fact that Lord Matthews in particular kept coming back to this point and kept getting Jonathan Mitchell to justify his line of argument. It doesn't necessarily mean that the judge thinks it's a bogus line of argument. He's just trying to ensure that it's robust.
No, that's exactly right. I mean, often you can see a situation where judges will be giving one side in a legal debate quite a hard time, and that doesn't mean that that side is going to lose the argument. That means the judges actually want to be absolutely sure what that argument is. And so sometimes it can be a good sign, but actually it's not really much of a sign at all. Yeah. It's just that there's one particular point that needed probing there.
Okay, well, of course, a lot of what Jonathan Mitchell was saying over the course of the last couple of hours was very, very personal in terms of how he looked at the conduct of Alistair Carmichael. Here's a flavour of what he was saying.
This false charge of this character, a false charge that Mr Carmichael was a minister who betrayed confidential documents, the Daily Telegraph. That would be a false statement as to his personal character and conduct. And the reason why, ultimately, it would be so is that this is fundamentally dishonourable conduct, which goes beyond politics. There's no more or less dishonourable, whether it is done by the minister or the civil servant.
So here again, this entire line of argument is that it goes beyond politics. This is all about personal, and clearly what the advocate is trying to do here is to put all of this conduct in terms of personal conduct in order that he can actually make a case within the terms of the Act. One of the other points, Professor Chalmers, which was made right at the beginning, this was after the point where I think Lady Paton asked Jonathan Mitchell about whether or not the Willis case was binding, was the whole decision about whether or not their determination in this case could be appealable. So just explain where we would stand at the end of this if one of the parties felt particularly aggrieved.
Well, an election court is an odd sort of court. As Jonathan Mitchell has been reminding us, we're in the Court of Session building, but we're not in the Court of Session. This is something rather different. So the Willis case was actually the first case where I think where this point arose, where Philip Willis wanted to challenge the decision of the court. And there isn't a Supreme Election Court, there's not a court you can actually go to. So he applied for judicial review in the same way as you can have a judicial review of the actions of, say, government administration. So it worked in a similar way. That would probably be the remedy here. As Jonathan Mitchell mentioned, the oddity there is judicial review in the first instance goes to a single judge. So the court would have to take some nifty procedural steps to avoid having one judge reviewing a decision of two. But there would be a route. Whether either side has the resources to allow for that is another question.
But normally, as I understand it, with judicial review, what a complainer is unhappy about is that perhaps an organisation has taken a decision and it's taken a decision which is not consistent with its rules, or it's taken a decision which is inconsistent with the concept of natural justice. So in terms of an election court, if you were taking it to judicial review, what would the sort of ground be?
It wouldn't actually, I think, look that different from a normal appeal. It would simply be an argument that the court got the law wrong in some way. There are other points that could be raised, but that would be the likely argument here, that somehow there would be a misapplication of the law.
And in the Willis case, was it on the whole basis of misapplication of the law?
It was, from memory, it's a fairly lengthy judgment, yes, it was. And there were some points where the divisional court there said that the election court had got it wrong. It didn't actually help Phil Willis. He still remained not an MP.
OK, Professor Chalmers, for the moment, thank you very much indeed for joining us this morning. Well, we are now going to take a short break, but as Lady Paton actually indicated, we will be back. Join us again at 5 minutes to 2. And welcome back to STV's coverage of Day 2 of the court hearing of the legal bid to overturn the election of Alistair Carmichael as the MP for Orkney and Shetland. This morning's session was taken up by the Petitioners QC, Jonathan Mitchell, setting out his key arguments. Let's go back to the court.
Interpretations. We find it on personal character and conduct in the cases referred to. We do not find it on the self-talking issue, where the first case is 1983, this post-1983 Act. The second point, everything that was said about the argument that there should be a restrictive interpretation of the language of the section. This is fully dealt with in Willis, in which the point is made, I don't want to go back to it, that the way in which this cuts is that the line is drawn personal versus non-personal. Having got that, there is no problem with the proposition that statements which are found to be false are within the Act. There's no place for restrictive interpretation upon who is a person and the like. But a side note to that, just in passing, there is no issue in this court of criminality.
Sorry, there's no issue?
There's no issue here of criminality.
Right.
Clearly, the election court is a strange creation in many ways, and there was a point historically at which it actually had the power of criminal sentencing. But none of that is I'm not sure how that worked, but certainly it's not in the Act as it stands. There is no more issue here. It is true that what is described as an illegal practice does create a criminal offence which can be prosecuted summarily in the Sheriff Court. There's no difference there to Mullen against Anderson. My submission, the talk about criminality goes nowhere, and the court can simply look at the issues before it in the ordinary way and the natural use of the language. The next...
By the way, you mentioned Woollis there, and we're not going back to it, but from your reading of the authority, can you tell us, was the case before the election court purely on submissions, or was there evidence before the election court? Can you?
From memory, there was evidence.
There was evidence, right. So that's witnesses and productions, is that right?
I'd have to go back and look at that. I don't have that in my mind.
Right, right.
Certainly, I have not researched Woollis in terms of its factual history beyond what is there.
Right.
And I think I have somewhere in my file the election court's decision as well. So
right.
What I can do is undertake, if the matter is not in the divisional court's judgment, but I can find it in the election court's decision.
You could let the clerk know.
Exactly.
Yes, well, that would be very helpful. If there's no objection to that, but it's simply the question, did they hear evidence?
I'm not offering to make further submissions on this matter, because it's a factual question.
Yes, factual question.
Yes.
Right.
What Woollis, of course, does show is that the factual context was taken as significant even upon the issue of is this personal character or conduct. Yeah. And I think one can see that by just reflecting how difficult it is indeed to answer that just with the cold words on the page. One would really want to see this leaflet.
Right. So I took you out of order there because you were moving on to your third point.
Yes. This is something I've said before, but it really is a nail that it seems keeps on coming out of the coffin lid. The suggestion that the real complaint, that was the phrase used yesterday, that the real complaint of the petitioners is the fact that the memo was leaked to the Daily Telegraph. It's been said repeatedly, and it's been picked up upon outside the court process. Absolutely not. I've said this before. The petitioners have no complaint that the memo was leaked. Whether or not it's, used Mr. Carmichael's phrase, a dirty trick or regrettable or anything of the kind, is not the point. We do not complain that it was leaked. What we complain about is the cover-up. That is what is seen as the issue of reputation. Just the same way as George Washington's father, mythically, because I don't believe the story is true, George Washington cut down the cherry tree and then said, "I cannot tell a lie," and owned up. That was more important. That's why the anecdote's created than the original act of vandalism. We do not complain about the leak. We do not complain of any non-statutory attack upon Nicola Sturgeon or upon the SNP or anyone else in the memo and the leak process and the Daily Telegraph article. The final concluding point before looking at the procedure point, there's a floodgates argument here. My lady and my lord will have heard this many, many times before, that the horrible spectre, if you allow this case to get away, others will come. What's strange about this one is this: there will be no likelihood of many more cases similar to this unless one agrees with a hypothesis, which I certainly don't support, that in fact there are far more false statements made by candidates of themselves than are otherwise made in the way that's been noted in the cases to date. That sounds highly unlikely. It may be true, who knows? But if it is true, it would be a healthy discipline if it was made clear that it had to stop at risk of petitions. The final point, the court's powers. The court has 3 issues before it. Issue number 1 is clearly a matter of pure law. And my lady and my lord will either be with us or with the respondent. Issues 2 and 3, more obviously 3, but possibly 2, do have a factual context. We say that they can be answered as matters of law for reasons which I have described and which, so far as issue 3 is concerned, is fully set out in our principal note of argument. And accordingly, the court should sustain on those on issues 2 and 3 as well. And in consequence, the conclusions follow under section 144 of the Act, certified to the House of Commons. But that failing, if the court takes the view that issue 3, and for that matter even if on issue 2, this is a matter for proof, the court will form its interlocutor accordingly by making plain that we are successful on issue 1, presumably issue 2, and the proof is so limited to issue 3. My problem here, which is mentioned in the note, is that if the issue goes to proof, we have had absolutely no indication given by the respondent as to what their position is on this. We have spelt out the history of facts, full chapter and verse. They say that the position is largely undisputed, and that seems to be correct. But if that's right, it's hard to see what it is that's supposed to be going to proof. And it might be that if my lady and my lord thought, nevertheless, it should go to proof, that the better way of dealing with this would be to put the matter out by order. I've said in my note of argument that we would wish to see the respondents ordained to state their position fully, but that can be discussed. The fallback submission anyway. The next point is this. This court is final. As we know, it's not appealable.
Sorry, as we know, it's
not. This court is final.
Not appealable.
Your decisions cannot be appealed.
Right, yes.
But we also know, looking at Willis, and of course that's now looked at in the light of the decisions in Cart and Eber, that it is a judicially reviewable body. But oddly, technically, it's reviewable in the courts of either England or Scotland. You are. But on forum conveniens principle, it's inevitably in the Court of Session. Now, just to guard against issues that might arise later, I would simply invite the court to write fully on all the 3 issues involved in this case, rather than, as a court might do, simply say, if we lose on one issue, that's it. The next oddity of procedure is this, that it's a 2-judge court. And section 144, subsection 3, does have provision if there is a difference between you. I'll just say on that, that seems to be contemplating a difference between members of the court that's essentially factual. because it's at page 305.
Right, better just look at that,
Yes.
I think. Right, 305, yes.
Section 144.
Right.
Subsection 3. The way this is phrased is differ as to whether the member was duly elected or returned. They shall certify that difference, and the member shall be deemed to be duly elected. Now, one understands how, if this is after proof, if one of you believes a witness and the other doesn't, that is struck at by 1443, we lose. But, if I may say so, if the difference between you was on a matter of law, such as we are discussing today, the better approach, in my submission, would be to state a case for the inner house under section 146.
Right. Just looking at section 146, here we are.
It's page 319.
Yes. Right. So there are routes available to the court in the event of these disagreements, yes?
I'm sorry?
There are routes available to the court in the event of a disagreement, as you're pointing out to us.
Absolutely.
Yeah.
And taking the self-talking issue, for example, which is pure law. If one of you agrees with my learned friend, one of you agrees with me, it's hardly appropriate. It wouldn't be happy if that was simply certified under 144 as a difference in the matter.
146. That's to do with a special case.
Yes, that's what I'm saying. If the two of you what this court has a power to do at any time is, if it appears it says there to the High Court, but I think this is yourselves. I'm possibly no. I wonder if I'm just looking at the wrong section.
I'm wondering about this, and it seemed to cover the.
I think I may be looking at the wrong section. That's the special case from the High Court, but there's a section. I am sorry, I think I've misnoted the section and I don't have the right one.
Right.
But my lady will recall, because we discussed this at the very first by order.
Yes, I do remember that.
There is a provision for the stating of a special case from the election court.
Perhaps we'd better identify which it is, nevertheless.
Says it's 146 subsection 5, but that is still of a stating by the High Court, which here means the Court of Session.
Right.
I think, in fact, yes. I'm sorry, I have to blush at this. I've misread the subsection 1. Where is the section?
Yes, I have to confirm, Mr. Mitchell, that it was section 146 that you referred to in July.
Yes.
So there, your submission was that if the election judges differed in their determinations, section 146 provided that a case could be stated to the inner house of the Court of Session.
To be honest, I'm not sure that I was pointing to the right section, because I have a clear memory that there was a section that dealt expressly with cases emerging directly from the election court.
Right.
The language is opaque, and 1461, although it appears to the Court of Session that the case raised by the petition may be conveniently stated as a special case, the Court of Session may direct it. But then, at subsection 4, if it appears to the election court at this hearing that any question of law as to the admissibility of evidence or otherwise, so today's questions, require further consideration by the Court of Session. I think that's it. This court may postpone the granting of a certificate under section 144 until the question has been determined by the Court of Session, and for this purpose may reserve the question by stating a case for the decision of the Court of Session.
Right, and where are you reading from there?
I'm reading and Scotticizing section 146, subsection 4.
4, right.
At page 319.
Right, right. It appears, any question?
So I think it will be a matter that if you disagreed on a matter of law, I would invite you to hold the question of law required further consideration by the Court of Session.
Right, and the High Court, in the circumstances, is that defined anywhere?
Yes, it's defined as the Court of Session, and that will be somewhere.
Yes, right.
Yes. Only thing I've been going, however, to say on this, which, if you are minded that in that direction, a case would have to be adjusted, and again, it might be better if the matter were put out by order.
Which is out by order, yes, indeed.
Because one thing clearly the parties would wish to be clear about on a special case procedure is just what it was that was going to the inner house.
Right, that's fine. Well, just looking at section 185 to see if the High Court is indeed defined there.
Yep.
No, I don't.
Not there.
I don't think it is. No, no.
But if,
Well, I think the best plan would be to put the matter out by order
if
there's disagreement. Yes.
Yes, exactly.
Right.
Yes. And you'll be relieved to hear that my last housekeeping points and matters of law was this. There was reference to the powers that the court might have, in Mr Dunlop's speech, to mitigation or remission.
Yes.
And the conclusion was reached, and I don't dissent from this at all, that's got no reference to this court at this stage, because it contemplates that following a determination in this court against Mr Carmichael, that the matter is then dealt with criminally and he's acquitted.
That's right, yes.
Pretty hypothetical. Can I just point, however, to section 167, which is at, 167 is at page 398.
Right. Yes.
Section 167, an application for relief may be made to the Court of Session. And my junior reminds me the definition section is section 204.
Oh, it's section 204, right.
Which is, I don't think is in the bundle. Or an election court. And the later words only apply to local elections. Where a person makes an application, he shall notify, it said there, the DPP, but no doubt to the Scottish provision, it doesn't matter for present purposes. Then, subsection 2, if it is shown to this court by such evidence as to the court seems sufficient that any act or omission of any person, in this context Mr Carmichael, would apart from this section be an illegal practice. In effect, they find that the false statement would apart from this section
does
be...
this apply to false statements? What relates to payments?
No, because that's the provision about... There are certain provisions that go to the county court.
Yeah, but the application is under the section. And an application for relief under the section may be made in respect of payments made, by the looks of it.
In contravention? No, an application for relief under this section may be made to the Court of Session or an election court, or in respect of certain payments to the county court.
And the heading to this part of the Act
is to accept innocent acts.
Yes, accept innocent acts from being illegal practice.
Right.
Yeah.
The false statement is defined as an illegal practice. So an application for relief can be made for the illegal practice of making a false statement.
Right.
Subsection 2, if it is shown to the court, that's this court, by such evidence that the court seems sufficient, A, that any act would apart from this section be an illegal practice, or various other categories. And then these are the tests. B, it arose from inadvertence or accidental miscalculation or some other reasonable cause of a like nature, and no want of good faith. So that's the first, that's the test on the merits. And then C is procedural. And under the circumstances, it seems to the court to be just that either that or any other person should not be subject to any of the consequences under this Act. The court may make an order allowing the Act, the false statement, to be an exception from the provisions of this Act, making it an illegal practice. And upon the making of the order, no person shall be subject to any of the consequences. Now, the way that seems to work is that if it is shown that the false statement was inadvertent or reasonable cause of a like nature, and no want of good faith, and it seems to be just that the consequences under the Act should not follow, then they don't. Now,
so
in reality,
a more powerful section than
Sorry?
a more powerful section than Section 174.
Absolutely. Section 174 really just deals with differences between two courts. Now, in reality, of course, no application has been made to this court under that section. But it is striking to note, I think, that on the facts of this case it couldn't be, because the drafter of this clearly contemplates that it has to be in effect accidental. Mr. Carmichael can't claim that. And quite rightly, he doesn't seek to rely upon it. But that is the get out, and as I say, it's really just by way of a footnote, because that is the section. It's not the other one. That concludes, you'll be pleased to hear, everything I have to say on this matter, unless I can assist the court further.
No, simply that undertaking relating to WULAS would be helpful.
Yes.
Well, we're very grateful to you. Thank you, Mr. Mitchell. Thank you. Yes, Mr. Dunlop, did you have one or two matters?
Lady Millard. On the question of procedure with which my learned friend opened, This court has the express statutory power to do that which a judge of the Court of Session sitting without a jury might do. That is section 123, subsection 2 of the Act. It cannot be the case, and I don't think my learned friend suggests it is, that faced with a petition which is irrelevant, this court should merely wring its hands and say, what can we do? And echoing my learned friend, why else are we here? We're here to discuss 3 discrete legal issues. And if any one of them is resolved in Mr. Carmichael's favour, then this matter ends now. There's no need to go back to 1868. Section 123 is clear. And in any event, my learned friend very fairly puts in the bundle, although I don't think we've heard of it thus far, a case which makes it quite clear that this court can dismiss on grounds of irrelevancy. It's the case of Hood against Gordon, which the petitioners submitted as part of the supplementary bundle at tab 6.27. And tab 6.27, and I'm looking at page 1045 of the joint bundle. Where that Master of Procedure, Lord McLaren, formed part of the election court. And so this is Hood, page 174 of the report, 1045 of the joint bundle. Lord McLaren, as regards a statement in Articles 1 and 2 dealing with charges of bribery and treating, I'm of the opinion that there's insufficient specification. So what he did there was require further particulars. And in the next paragraph, petitioners have indicated their intention to amend, and I propose we should allow such amendments. As regard Article 3, dealing with illegal payments or payments not included, I think the respondent's objection ought to be sustained. There are no relevant averments in the article upon which the petitioners would, in my opinion, be entitled to allowance of proof. So his lordship draws a useful distinction there. If it's a plea of want of specification, then the appropriate thing to do is to require further particulars. I make no such complaint here. If the complaint is relevancy, then the appropriate course of action is dismiss. My learned friend said, well, relevancy, it's all about fair notice. No, it's not. A plea of want of specification is about want of fair notice. A plea of irrelevancy is that it is bad in law. And that is the sum and substance of my submission on all 3 heads. And the court bears in mind the purpose of this hearing as agreed in advance. It was to discuss these 3 discrete legal issues. That's why we have no statement of evidence. Rule 69.13 says, put in a statement of the evidence you intend to lead. We intend to lead no evidence at this part of the trial because we say the thing is irrelevant. Other than that, my lady and my lords, I don't intend to detain the court on questions of procedure. If the result is that I am successful on any one of the 3 heads, then I would move the court simply to dismiss, as previously discussed. If not, then I don't demur from the suggestion that a by order would be appropriate. Right. If I might take issue 3 first now, because it's the quickest to deal with. issue 3 is effectively conceded because Milan and Friends says, hands up, a purpose to affect the general election doesn't work. I agree with that. But he says, look at my note of argument, I'm really offering to prove something else. The short point I reiterate is he offers to prove both, because the rules make it quite clear we can look at the petition and the note. He offers to prove either or, affect the election or affect the general election. And one of those doesn't work. And his analogy with the Factories Act case was telling. He said, well, if I come to court and say I was hurt and the machinery was unsafe, or if it wasn't unsafe, it wasn't properly guarded, well, those are both relevant. Those are both relevant averments of fact. Here, he says you either intended to affect the general election or you intended to affect your own election. They're both averments of fact, and one of them will not wash. And while we're on issue 3, Milan and Friend, despite effectively conceding it, then goes on to say, but you can determine it now on the pleadings in his favour, he says, because the only reasonable inference is an intention to affect the election. Well, that can't be right, because in the petitioner's own averments, there's another inference, i.e. an intention to affect the general election. And in any event, we are not here to discuss a motion for decree de plano. That was not one of the agreed issues. That's all I have to say about issue 3.
Right.
And I can be similarly fairly brief on issue 1. Milan and Friend refers to the report from the Select Committee. And it's a report which he has to accept. There's only so much he can take from it because it's not a complete report. That report does not fall within the ratio of Pepper because it's not a clear statement from the promoter of the bill. And if I can remind the court that when we do have a statement from the promoter, Mr. Bolton, we have a statement about the bill in its unamended form. What is subsequently passed? The bill in its unamended form. Milan and Friend says you can't use Pepper if the promoter didn't get his way. He did. He promoted a bill in the terms passed by Parliament. And the fact that there was an amendment that was rejected tells us nothing other than that Parliament didn't deem it necessary to amend. When we go back to what was actually said at the second and third readings, it's all about vilification and slander. And what it's not about, at any point in the discussion prior to the inception of the Act, is self-talking. And I do come back to what Lord Kilbrandon said in Grieve. It can hardly be only now, in 2015, that one can contemplate that a politician might say something about himself with which others disagree. That possibility is surely as old as politics itself. and if Parliament intended to catch it, it might be expected to have said so expressly. Again, that's all I have to say about issue 1.
Right.
So that just leaves us then with issue 2. Now, my learned friend looked at the bank's case, primarily under reference to issue 1. But he was then very critical of counsel for Mr. Banks. And it's interesting to look at why that was so. He said, "I would have thought there could be no stronger example of a political statement to state that one was the official candidate of such and such a party." But Mr. Lewis spoke falsely, and he knowingly spoke falsely. So the primary basis upon which the petitioner's case is put, in the pleadings and in the note, that falsity turns this into the personal, is on his own submission, unfounded.
Just repeat that last proposition, Mr. Dunlop. The primary
basis upon which the petitioners put their case, in both the petition and the note of argument, and for the notes I have here in mind paragraph 13 of their note, which is that the falsity of a statement turns it into personal because it impacts on trustworthiness, is on his own submission unfounded. Now, we've heard of Kitty O'Shea and Phineas Finn of the Reichstag in 1933, of Douglas Stringfellow. I beg leave to query what assistance we actually get from any of that. And I urge the court not to be diverted from what is, in essence, a very simple question. For the purposes of section 106, a statement is either personal or it is not. It cannot be both political and personal. Willis could not be clearer on that. Now, my lady in the chair asks my learned friend, is Willis binding? We are in the UK Election Court, a statutory tribunal, which has been judicially reviewed in Willis. I cannot think of any situation in which a tribunal that has been reviewed by a court would be entitled to simply thumb its nose at that decision. In my submission, Willis is binding. If I'm wrong about that, it would be most unfortunate to find a different approach north and south of the border on fundamentally important issues like this. And I recall my learned friend's glowing endorsement yesterday and today of Mr Morrison QC, who my learned friend indicates has more knowledge of electoral law than anyone else in the kingdom. Well, in Erlam, I'll just give the court the reference. Erlam, the first of the Erlam, 6.22, at paragraph 113, joint bundle, page 932, Commissioner Morrie described Lord Justice Thomas's exposition of the law in Willis as magisterial. And at paragraph 117 of the same case, in which he was sitting as the election court, he said he was bound by Willis. My submission, he was correct in both of those descriptions. Looking beyond the technical into the substance, there is no dissonance between paragraph 111 and paragraph 121 in Willis. It would be highly surprising if the Lord Chief Justice had made such an elementary error, having told us what the law is at paragraph 111 and 10 paragraphs later, forgotten what he'd said. All he says at 121 is that a comment made in a political context, and under this Act, we're always going to be dealing with a comment made in a political context, can transcend the political and impact upon the personal.
Does that mean it's both political and personal?
No, my lord. It means it transcends the political so that it is no longer political and it becomes the personal. That's the way his lordship puts it at 121 and at 124. Now, it's easy to see how that can be the case in the context of attacks. It is less easy to see how that can work in the context of self-talking. But what it can't do is to mean that as soon as one speaks falsely, it becomes personal. And that is shown by the further point my learned friend makes. He says, you've got to look at this in the way that an objective bystander would look at it. Would the bystander understand that a comment was being made about personal character or conduct? The objective bystander hearing a false statement doesn't know it's false. He only finds out later, as was the case here, that there is subsequent discovery of the falsity. That discovery of the falsity weeks later does not operate as some sort of time machine. Take one back and turn the statement when it was made into something other than that which it was. So when my learned friend responded to my Lord Matthews' question by saying it relates to his personal conduct in telling a lie, he advances a proposition which is wrong in law. And it is here that Malone and Friends submission faces an insuperable difficulty. He was repeatedly asked about the categorisation of the leak, and he began by emphasising that the criticism is not the leak. That was dealt with by Cabinet, and he could not suggest otherwise. Why? Because it's political. My learned friend then suggested that Lord Matthews was mixing two questions up. Well, with respect, he is not. With respect, the nub of this matter is the very one alighted upon by Lord Matthews. Because unless the allegation of leak, or more appropriately, and I'll come back to this, an allegation of knowledge of leak, was a personal matter, a false denial of that simply cannot be a personal matter. Pressed on this issue this morning, Malone and Friends said, I find it quite difficult to categorise an allegation of leaking the document as either personal or political. Well, if this court finds itself in that self-same difficulty, Mr. Carmichael wins. Because then we are squarely within the dictum of Mr. Justice Brett from Benyon. The narrow construction means, in the case of doubt, it is resolved in favour of Mr. Carmichael.
Well, we need to go that far. If we were in that position where we could not say that it was personal, as opposed to political, on ordinary rules, then the petitioner would lose, would it not? Would they not?
That's maybe a simpler way of putting it, my lord. I don't have any difficulty with that. But in truth, my lady and my lord, there is no such difficulty. My learned friend's difficulty in facing up to the question lies in the central context which the petitioners themselves found upon. The Scottish Office was in receipt of a memorandum damaging to the SNP. The respondent was asked to assent to the leaking of that document. Why was he asked? Because he was the Secretary of State for Scotland and in charge of the Scottish Office. A false complaint that the Secretary of State authorised a leak by the Scottish Office can only be seen as public or political. It is a world away from the treason contemplated in North Louth. And in that latter regard, one must read North Louth in light of Willis. In particular, paragraph 109, where the court emphasised that what was said in North Louth is far from clearly expressed, unnecessary for the purposes of decision, and therefore obiter. In closing, My learned friend advocates parliamentary reticence. Mr Carmichael should have said nothing. And if he'd done so, he'd have been fine. But consider what he actually did say. Because much of the discussion has focused on what has been claimed to be a false denial of involvement in the leak. He wasn't accused of involvement in the leak. That was not the context, as is clear from the petition, of the question. What were you aware of? It's fair enough to ask, as Secretary of State, what did you know? A false denial of knowledge of the source of a leak is yet one further step removed from a false denial of involvement. If that does transcend the political and shade into personal, almost any false denial will. The true analysis is, as I said yesterday, this was political from start to finish. It related to what the Secretary of State did as head of the Scottish office. And he actually said nothing about his personal character or conduct. The absolute worst for Mr Carmichael is a loose or consequential impact. When I say impact, I ask the court to ignore references to Mr Carmichael's apology. That cannot affect the reasoning. If Mr Carmichael had been wholly recalcitrant, I'd hardly be here saying, look, didn't do anything wrong. At worst for Mr Carmichael, there is a loose or consequential effect, and on the authority of Martin against most and Fairbairn against the SNP, that is not enough. And for these reasons, which are merely supplementary to those advanced yesterday, I adhere to the submission that this court should bring an end to this matter now by ruling that the petition is, in law, irrelevant. Unless there's anything further.
No, thank you very much indeed. Thank you. Well, we'd like to thank both counsel and their juniors for their excellent submissions and for all the research done in this fascinating case. And we also want to thank those instructing counsel for the very well-organised papers. What we'll do now is announce that this part of the trial has come to an end. So what we'll do is adjourn the case to the next part of the trial, whatever that may be, and it will be a date to be fixed. We need time to consider the submissions that we've heard, so we'll be taking these submissions to avizandum, and we will issue a written judgment, or it may be a written report in terms of the statute at a later stage. But I think these are all the matters that we can deal with today, and court will now adjourn.
Court.
So, after 2 days of proceedings, the court hearing has now drawn to a close. Still with us is James Chalmers, Professor of Law at Glasgow University. Now let's pick up in the very last point that Lady Paton made, that we are finished with this part of the proceedings. We then go on to the next part of the trial, whatever that may be. So just what are the options which the two judges are faced with?
There are, well, there are two main options. One is simply to decide the case either way, either decide that the petition is, as Mr Dunlop put it, irrelevant and the election stands, or to decide that Mr Carmichael's election is void. The other major possibility is that they feel they need to hear evidence in some way, but neither side, I think, seem terribly keen on that, but there is still the possibility of an evidential hearing and Mr Carmichael giving evidence. The third slightly complex possibility that Mr Mitchell brought up was, this is unusual, it's a court of two judges, which is actually not a very good way to design a court. What happens if they disagree? Well, one option there is that they would have to state a special case to be heard by the Inner House of the Court of Session, heard by 3 judges. We would go through all this again. I suspect nobody really wants that.
I think that was under section 146, subsection 4, if I was paying attention enough. So, I mean, if we were to get to that stage, and this is obviously in the context where Lady Paton and Lord Matthews disagree here, we have to hear all of this again, do we?
Very possibly, yes. I don't think that will happen. I would be.
Oh, there's no provision for going to the court and effectively asking for some other judges to take a look at what has been put before them and to say to them, well, which one has read it correct in law, Lord Matthews or Lady Paton?
Well, that's effectively what would happen if a special case were stated. They would have to identify what their own positions were and essentially ask the Inner House for a ruling on the law. So it wouldn't be everything again. It would probably be one point of dispute. I really don't think that's likely, but it's an option that Jonathan Mitchell was right to canvass, because it is a problem when you have a two-judge court.
Although there are a number of tests, and we have come back to these tests during the broadcast, yet again, even in the closing statements there that were being made, they still come back to this issue of the personal against the political, and Roddy Dunlop returning to the issue again and again and again. Do you sense that the entire case will turn on whether or not the judges look at Mr Carmichael's conduct and judge it to be political or personal?
Yes, so that's the most obviously potentially decisive issue here. One point, though, that was interesting was that Jonathan Mitchell said that he would invite the court to write fully on all the issues, because it's possible, as both sides have accepted, that if the court finds in Mr Carmichael's favour on simply one issue, the petition falls, his election remains valid. That request to invite the court to write fully on all issues is interesting, because it does suggest that the petitioners have not entirely ruled out the possibility of seeking judicial review if they lost the case.
Well, Lady Paton described it as fascinating. Of course, folk in Orkney and Shetland will have been following this over the course of the last 2 days. Let's go back to Orkney and to our reporter, Nicola McAlley.
Well, Bernard, as you say, people up here in Orkney and in Shetland have been glued to this, keen to see how this hearing was going to pan out. I'm with one of the petitioners now, Carrie Welling. Just tell us, what's your thoughts on it? You've heard all the submissions now, and you brought this case. You're one of the 4, the Orkney 4. Just give us a quick overview of how things were for you.
More or less, as I said first thing yesterday morning, it's about whether this law applies, and both of the QCs made very, very strong cases for whether it did or it didn't. And it's extraordinary, really, how it's not clear-cut. You know, it's not obvious whether this law applies or doesn't apply. And it's a judgment. It's going to be a judgment by those 2 judges. And I really can't wait to find out, but...
This is STV Edinburgh. Let's see what our friends at the other end of the M8 have been up to. It's the Riverside Show.